All right. Good morning, everybody. Today is September 28th, 2021. It is 9:28 a.m. and this is a special meeting of the Oil Conservation Commission. I'm Adrienne Sandoval. I'm chair of the Oil Conservation Commission and head of the Oil Conservation Division. Also with me today are our other two commissioners. Would you please introduce yourselves for the record?
Yes, good morning, Madam Chair. Terry Warnell for MNERD.
Good morning, Madam Chair. Esteban Baca with New Mexico State Land Office.
Thank you. First item on the agenda today is the approval of the September 16th, 2021 minutes. Commissioners, is there a motion to approve the September 16th minutes?
I move to approve the minutes.
Is there a second?
Madam Chair, I second that motion.
Mr. Milliner, would you please do a roll call vote?
Absolutely, Madam Chair. Commissioner Baca?
Yes.
Commissioner Warnell?
Yes, approved.
Madam Chair?
Yes.
Motion passes.
Thank you. Next item on the agenda is the approval of the agenda. Commissioners, is there a motion to approve today's agenda?
I move to approve the agenda.
I second that motion.
Thank you. Mr. Milliner, would you do another roll call vote, please?
Happily, Madam Chair. Commissioner Baca?
Approve.
Commissioner Warnell?
Yes, approved.
Madam Chair?
Approve.
Motion carries.
Thank you. All right, moving on to agenda item number 4, which is case number 21872, application of Titus for approval of production allocation. All right, before we get going on that, let's see. I want to make sure we've got all the parties here. Ms. Shaheen, can you just do a quick sound check?
Good morning, Madam Chair, Commissioners, Council. Sharon Shaheen on behalf of Titus Oil and Gas Production.
Thank you. Do we have the division?
Good morning, Madam Chair. This is Jesse Tremaine, representing the division.
Thank you. State Land Office?
Good morning, Madam Chair, Commissioners. Nicholas Collins sits here on behalf of the NMSLO. Thanks for the opportunity to be here.
Thank you. Let's see, representatives for EOG.
Madam Chair, members of the Commission, Michael Felderwerth with Santa Fe Office of Holland and Hart, appearing on behalf of EOG Resources, Inc.
Okay.
Mr. Felderwerth, you're fading away. You have to get a little closer to your mic, sorry.
I will do that.
Thank you. Representatives for Pegasus.
Good morning, Madam Chair. Michael Rodriguez, representing Pegasus Resources, LLC, Fortis Minerals 2, LLC, and Santana Elena Minerals 4, LP, which will be collectively called Pegasus.
Thank you.
Thank you.
All right, I think that's everybody. First, I will open it up, and if any of the parties would like to make a brief opening statement before we then go into direct testimony. Ms. Shaheen, would you like to make any brief opening statements?
Yes, I would, if I may. I appreciate that.
Go ahead.
As a threshold matter, I'd note that the division is taking a position that that Titus has somehow created this accelerated timeline, and we're going to address that today. Titus has been planning this development for about a year now, and first began conferring with each of the agencies back in November of 2020, and Mr. Jones will testify about that. After conferring with all of the agencies, starting in November. The application was filed on April 6th, which was almost 6 months ago. When the application was filed, all of the interested parties, including the agencies, received notice, but only the division entered an appearance at that time. Of course, subsequently, the State Land Office entered an appearance. And I believe we've reached an agreement with the State Land Office, and I'll let Mr. Kalinsich address that. Some important points about the division's position, because it does oppose the application. The division does not take any issue with any of the technical aspects of this well. So they've admitted that at their pre-hearing statement on page 3. They do not dispute that the proposed well will prevent waste. They don't dispute that it will protect correlative rights. They don't dispute that this well will have less environmental impact. The division only argues that it has a number of unspecified fears about what might happen if this application is approved. And this is notwithstanding the fact that Titus has agreed that it will be required to comply with all New Mexico regulations. And of course, any order that the division or the commission issues will require that compliance as well. We believe the division's concerns are more about drilling from Texas into New Mexico. Titus does not propose to drill from Texas into New Mexico. It only proposes to drill this well and any other subsequent wells related to this development plan from New Mexico into Texas, and this well will be subject to New Mexico regulations. There's nothing unique about this well. There are other interstate wells. Granted, they don't include production on both sides, but we know of at least one other well drilled in Texas and completed in New Mexico where no memorandum of understanding or any type of agreement was required there. Today, we will be showing you that there is no impediment to the Commission's approval of the application. The division has authority. We've addressed that authority at page 7 of Titus's pre-hearing statement. And there's section 70-2-6 of the Oil and Gas Act, delegated jurisdiction and authority to the division and the Commission over all matters relating to the conservation of oil and gas. The Commission is empowered and obligated to prevent waste and to protect correlative rights under section 70-2-11. Section 70-2-12 provides a broad list of enumerated powers that enable the Commission to exercise its authority and jurisdiction and satisfy its obligations under the Act. For example, 70-2-12, B7 provides that the division may make rules and orders to require wells to be drilled, operated, and produced in a manner to prevent injury to neighboring leases or properties. And in section 70-2-17B, the legislature provided that the division may establish proration units, and in so doing, consider the economic loss caused by the drilling of unnecessary wells, protection of correlative rights, prevention of waste, and the usual considerations of the Commission. Notice was proper to all parties that have an interest, and we'll step through that briefly with Mr. Jones. This is a standard spacing unit where Titus proposes to penetrate 40-acre tracts. It satisfies the standard setbacks, except for the fact that the well will cross the interstate well. It, as noted, it will prevent waste, protect correlative rights, minimize surface disturbance and environmental impacts. If this proposed spacing unit were wholly within New Mexico, we would have had no reason to seek approval from the division other than approval of the application for a permit to drill. It's a standard proration unit with standard setbacks and a voluntary agreement among all working interest owners. And thank you for allowing me to make that opening statement.
Thank you, Ms. Shaheen. Mr. Tremaine, would you like to make an opening statement for the division?
Yes, Madam Chair, thank you. Good morning, Madam Chair, commissioners and parties. I want to make a few opening remarks to kind of set the OCD's presentation in context. The division maintains that several legal and policy concerns regarding interstate wells. What the division wants is the opportunity to negotiate an interstate agreement with Texas in a manner that focuses on mutual interest and process, not one that highlights differences in regulation and policy. It doesn't benefit the agreement, the parties to this case, the future of interstate development, which generally OCD does not oppose, to publicly point out OCD's concerns with Texas's approach or Texas's concerns with New Mexico's approach. This isn't about Titus specifically, it's about how Titus's application impacts larger considerations related to cross-border development.
Mr. Tremaine, when you read, it sounds like a robot. It's very hard for me to.
Well, I certainly don't want to be robotic. I'm trying to move very efficiently for us here, so I will endeavor to be less robotic. The bottom line is that New Mexico and Texas should agree on rules for interstate development before the interstate development occurs. This interstate development, specifically the commingling of resources obtained from both New Mexico and Texas, is novel. It's a new development. So a couple points. Titus has everything it needs to drill an economic well in New Mexico. We'll be touching on the waste argument presented by Titus. The Oil and Gas Act should not be construed to prohibit waste in Texas. That's not how state laws work. Neither the division nor this commission should be compromising New Mexico policy and regulation to accommodate prospective interests that are otherwise facing access hurdles in other states. When the states agree on those ground rules that I previously mentioned for interstate production, great. Before that, proceeding without knowing what those ground rules are just represents bad policy. Titus's waste argument, as it applies to setback, is overstated and strained. Setbacks exist for legitimate reasons. This particular setback is established in rules set after public hearing on a rulemaking. 100 feet was deliberately chosen to avoid stranding acreage without impacting correlative rights beyond the boundary. It's not waste. That 100-foot setback is set for specific reasons, and that's one of those reasons is to avoid waste. The other reason is to avoid impacting correlative rights on the other side of the boundary. Titus does not have a current legal right to drill across New Mexico's setback and across the border into Texas. They've known what their rights and permissions have been for quite some time, but despite being told not yet by the division, Titus put a drill rig on the pad before they had permission to drill into Texas. That's their choice. That's not this commission's problem, and it should not be a reason to force the division to expedite an agreement with Texas. Titus is requesting the division and now the commission for approval to start a novel project. I want to stress that point. It should not be lost, regardless of how forcefully Titus asks. Titus's assurance that it will comply with New Mexico rule is irrelevant. Titus cannot commit Texas. Texas has authority to regulate oil and gas and other minerals in Texas. So OCD is reasonably concerned that Texas may dispute application of certain New Mexico rules to Texas minerals, and more on that later. The precedential value, which was cursorily dismissed by Titus, that value is important. OCD's concerns are concrete, specific, and in fact are evidenced by the filings in this case. Titus and Pegasus are already making precedential arguments in support of their respective filings. They claim that OCD did something analogous before in another situation, and so therefore the commission should approve their application in this situation. That's significant. The suggestion that the commission could approve a well in New Mexico that produces from Texas, but could deny a well that's in Texas that produces in New Mexico is inherently problematic. Likewise, the suggestion that an MOU or any other form of agreement should only address wells in New Mexico that drill into Texas is an unworkable proposition. I think that would be seen as one-sided and patently unfair and subject to collateral legal attack. OCD's concerns are not hypothetical. In fact, I think they're projectable. So what happens when Texas doesn't like the fact that their mineral resources extracted through New Mexico are now subject to a gas capture requirement? Likewise, when there's a well in Texas that extends into New Mexico, is OCD going to agree to a structure that allows operators to circumvent those gas capture requirements? What happens when there's an inconsistency in approved downhole spec? How is that resolved? What happens when there's a problem with drilling a lateral? Which agency takes lead on that? One of the issues, what happens when one of the agencies issues an approval with conditions which on their face apply to the well, which is located in the other state? And I'm pointing this out because it's already happened. What happens down the road when Titus or another operator has an interstate well and the operator goes bankrupt and OCD has to P&A the well and remediate the site? Who bears those costs? Those are all examples of legitimate projectable issues that when they come up, the parties will be wishing they had an agreement ahead of time. Lastly, I want to say that the deadline for an MOU is patently unreasonable. While OCD will accept and comply with any deadline set by this commission, the larger deadline for an MOU is completely unenforceable. OCD cannot make the Railroad Commission agree to anything. It's also contrary to interest of New Mexico to meet an arbitrary deadline because that can impact the quality and the content of an agreement. And OCD wants an agreement. Development under an agreement could benefit both states. Titus is focused on production allocation as the only question before the commission is incorrect. That is at best too narrow focused and at worst it's obtuse. The only reason that would be the only question before the commission is that it's the only thing that Titus wants the commission to look at, and that's the only question that they've asked. The division is asking the commission to consider other significant concerns that the division's bringing forward. OCD does not believe that an agreement has to be perfect and address every outcome, but it needs to be in place before the reasonably foreseeable disputes come up. In some, OCD is generally in favor of interstate agreement, but it needs the opportunity to develop that agreement in advance of interstate development so that it's not left figuring out complex interstate policy and how these two particular agencies that have not worked together before to share jurisdiction over interstate wells with the commingling of mineral resources on the fly. Thank you.
Thank you, Mr. Tremaine. Mr. Kolensich, would you like to make a brief opening statement for the State Land Office?
Yes, I would. Thank you very much. Good morning, Madam Chair, Commissioners. Nicholas Kolensich on behalf of the NMSLO. After discussions with Counsel for Titus, the New Mexico State Land Office can stipulate to remove its opposition and take no perspective on the application if we can make a record of Titus's approval and OCD so orders certain conditions of approval for the application. To be clear, this is a one-off singular agreement in light of time and practical realities of this novel project and to optimize efficiencies for drilling. We do not stipulate to this being some sort of precedent that would be allowed in future cases. There appears to be unanimous agreement that the state of New Mexico has to be adequately represented before the Texas RRC, including the New Mexico State Land Office. Similar to what we put in our submission before the court, forgive me for reading and I'll try to do it slowly. Wishing to ensure adequate and mutually satisfactory oversight while allowing the application to proceed, subject to OCC approval and order. Parties, the NMSLO could stipulate and agree that in exchange for the New Mexico State Land Office withdrawing its opposition to Titus's application, Titus should agree to support the regulatory authority by New Mexico and stipulates the following conditions of approval before both the NMOCC and the Texas RRC. First off, that New Mexico has to be involved in any JOA or MOU that's reached with the Texas Railroad Commission. allocation of revenues in proportion to surface area, reporting of production amounts and revenues, financial assurance and security, bonding, letters of credit, cash bonds, etc. Permitting of this and related future operations, environmental issues such as regulatory compliance, air and releases. Specifically, venting and flaring should be governed by New Mexico rules. Adequate notice to stakeholders and parties, inspection of operations and lands, plugging and abandonment, jurisdiction over all controversies in the New Mexico administrative and judicial forums, compliance with all regulatory and environmental compliance between the two states under New Mexico law. Titus will agree to argue and support the final MOU substantially in conformity with the terms of the draft MOU, which we submitted. Titus would stipulate and agree to present this position before the OCC and the Texas RRC, subject to obviously an approval and an order from this body. Under these circumstances, the NMSLO would not endorsing the project, we are withdrawing our opposition. If I was sloppy or incorrect in any of that language, I would welcome a correction from Titus's counsel, but that is our position.
Mr. Kalinsich, this is Chris Moander, counsel for the commission. Just to make sure I'm understanding the sort of the sourcing for this, that it sounds like you reiterated the list from page 3 of your SLO's response to other pre-hearing statements. Is that fair and accurate?
Very simple, and that'll make it easy for everyone to see it.
Thank you.
No, thank you.
Thank you. Mr. Feldowert, would you like to make an opening statement?
Madam Chair, members of the commission, I think it's more of a statement as to why EOG is here.
Sorry, I cannot hear you.
Volume up.
Can you hear me better now? Thank you. So, Madam Chair, members of the commission, my statement is more as an explanation of why EOG is present in this case. They actually own leases in Texas to the southeast of Titus's tract. And to my knowledge, Titus is not engaged with EOG in a discussion on how to develop that acreage along the state border. So that's the reason that EOG is here today and is an interested party in this particular matter.
Thank you, Mr. Feldowert. Mr. Rodriguez.
Yes, good morning, Madam Chair, members of the commission and council. I have a short opening statement I'd like to present.
Fine.
Thank you. The Pegasus entities are a party of record and have an interest in Titus's proposed spacing unit and support Titus in this matter. Pegasus submitted a brief in support of Titus's application to the division on September 2nd, 2021, and included this brief in its response to the division's pre-hearing statement, which was submitted on September 24th, 2021. This sets forth Pegasus' position in this matter. And I'd like to point the commission to a clarification regarding Pegasus' response to the division's pre-hearing statement. As to the statement made in paragraph 3 of page 1 regarding OCD approved wells drilled from New Mexico to Texas, it is Pegasus' understanding that wells have been drilled from New Mexico into other states, which include Colorado, but that we do not have specific information on wells drilled from New Mexico into Texas. And with that, Pegasus requests that the commission consider Pegasus' brief on the matter and approve Titus's application. Thank you.
Thank you. All right, Ms. Shaheen, would you like to call your first witness?
Yes, thank you. Mr. Walter Jones is present. He is the landman for Titus. We also have available for cross-examination Mr. Frierson and Mr. Hickey, the geologist and engineer respectively. my plan today was to walk through the testimony, summarizing the testimony that was presented before the division with Mr. Jones, and also walk through the rebuttal exhibits that we have. Because the division had not previously challenged the technical aspects, I didn't think it would necessarily be helpful for us to walk through the geologist testimony or the engineer testimony, but I think we can facilitate that if you would like. So with that, I would ask that Mr. Jones be sworn in.
Ms. McFarland,
Yeah, I'm not sure. Usually the OCD swear. Do you want me to swear him in?
Sure.
I mean, I don't know. OCD, it's usually the examiner swears him in, but whatever you want.
Yeah, if you want to go ahead and swear him in, that would be great. Thank you.
Mr. Jones, would you raise your right hand, please? And I don't see him anywhere. Do we
Can you
have
see
him?
me?
I can't see you. There you go. Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Good
Thank
morning,
you.
Mr.
Go ahead and proceed, Ms. Shaheen.
Thank you. Good morning, Mr. Jones. I'd like to start with the rebuttal exhibits that were submitted with the Titus's response to the Oil Conservation Division's pre-hearing statement. Do you have that available in front of you?
I do.
And I'm hoping everyone else will as well. The materials that have been submitted are somewhat voluminous, and what I've done is I've tried to identify the PDF pages for everything that we're going to be looking at today, and I'll try to point you to that PDF page. So if everyone has the response, Titus's response to OCD's pre-hearing statement, those are the exhibits that we'll be taking a look at now.
Madam Chair, if for no other reason than for posterity, I need to object to the introduction of the exhibits, which were filed 3 days after the response deadline. But if the commission wishes to proceed and discuss the exhibits, I will not persist in that objection.
And I'm happy to respond if that would be helpful for the commission.
Go ahead.
Yes, these are rebuttal exhibits, and they're rebutting arguments made by the division in their filing on Tuesday. I believe that was September 21st. They are submitted with along with our response to that pre-hearing statement, and as a result, under the rules of civil procedure, which are ordinarily used in commission and division hearings, the rebuttal exhibits are timely. And as everyone knows, we don't have a jury here, so don't believe that anyone will be prejudiced by misunderstanding the fact that these are rebuttal exhibits.
So I think since they're rebuttal exhibits, they can be added to the record. Your objection is noted, Mr. Tremaine. But I think we can proceed, and I guess asking other parties, are there any other objections to these exhibits being entered into the record?
Madam Chair, something else to keep in mind is that these were, as I understand it, I'm only seeing one exhibit attached to the response. But if they were attached as exhibits to the pleading, I know that's generally already part of the record at this point because it's what accompanies a filing. So, I mean, unless there's additional challenges to like foundation, I don't see an issue.
Are there any other objections from the other parties? How about any of the commissioners? Okay. And I think it was Exhibit A is entered into the record.
These are actually attached as Rebuttal Exhibits 1 through 15.
Sorry. Rebuttal Exhibits 1 through 15 are entered into the record. Mr. Moiner, do we need a vote for that? I can't recall. Enter the
No, Madam
exhibits.
Chair, this is an evidentiary ruling, so I don't believe a roll call vote is required for that.
Thank you. Okay, go ahead and proceed, Ms. Shaheen.
Thank you, Madam Chair. Mr. Jones, can we start just by you telling the commissioners when Titus first began working on this particular proposal?
Sure. Yeah, I believe we originally started having internal conversations in, it was likely September or October of 2020. And it was at that point that we decided to pursue it. And so we started reaching out to some of the involved parties just to start fact finding and gathering information as to what it may look like to pursue a project like this.
And turning to Titus's Rebuttal Exhibit 2, which is PDF 11, in the response to the OCD's pre-hearing statement.
Okay.
This is an email chain between Ryan DeLong and Daniel Sanchez at the division. Is that correct?
That's correct.
Can you explain to the commissioners who Ryan DeLong is?
Ryan is it's Titus, our company. He is our regulatory manager.
And you've spoken with Mr. DeLong about these exhibits and his emails. Is that correct?
Yes.
And later on, we'll actually be reviewing some emails on which you were copied, correct?
Yes.
So taking a look at the email that's farthest down on the page here, PDF 11, this email is, what is the date of this email?
November 10th, 2020.
And can you just explain briefly what the email is about?
Yes, it's a follow-up to a phone call that Ryan had with Mr. Sanchez, just socializing some of the plans or the plan to drill across the New Mexico, Texas state line. Then he also just followed up with kind of some or not really bullet points, but just some parts of their conversation.
And then the email directly above that is dated December 4th, 2020. Do you see that?
Yes.
And that again is from Mr. DeLong to Mr. Sanchez. Is that right?
That's correct.
And can you tell us the nature of this December 4th email between Mr. DeLong and Mr. Sanchez?
Yeah, so after the November conversation and then follow-up email from Ryan to Mr. Sanchez, I do not believe he heard anything back from Mr. Sanchez, so he reached out with a follow-up email copying his previous email just to try to get some feedback on the initial email.
And turning now to Titus's Rebuttal Exhibit 3, which is PDF 13.
Yes.
And this email is between Mr. DeLong again, and you're copied here. And he sends this email to Brandon Powell at the division. Is that right?
That's correct.
And can just briefly tell us what this email states to Mr. Powell?
So he is following up on a voicemail that he left with Mr. Powell I believe that Mr. Sanchez in a phone call said it would be best for Ryan to continue to pursue this by reaching out to Mr. Powell. And so he called and left a voicemail and then followed up with this email, again, with a summary of what the project is and what we're asking feedback from the OCD for.
And that was January 5th of this year, correct?
That's correct.
Turning now to Titus's Rebuttal Exhibit 4, which is PDF page 15 of Titus's response. This appears to be another email between Mr. DeLong and Mr. Powell. Do you see that?
I do.
And what is the date on this email?
March 31st, 2021.
And what does Mr. DeLong say to Mr. Powell in this email?
He's saying, I've left you a few messages over the past couple of days and wanted to follow up with an email in hopes of finding a time to discuss our multi-state wells. In particular, he mentions a conversation that he'd had with Mr. Paul Katz at the OCD, suggesting that it may be a production allocation issue for OCD review and approval.
And turning now to Titus's Rebuttal Exhibit 5, which is at PDF 16. I see here another email between Mr. DeLong and Mr. Powell from Mr. DeLong to Mr. Powell, and this one appears to be dated April 15th, 2021. Do you see that email?
I do.
And just, this is a very brief email. Can you summarize it for the commissioners?
Yes, it's a follow-up to a phone conversation that between Mr. DeLong and Mr. Powell, that just confirming that Mr. Powell is reviewing the proposed interstate lateral, and that it would not go through the NSL application, but would go through the NSPU application process, which would be the non-standard proration unit in being NSPU instead of a non-standard location being an NSL.
And this is the reason that Titus noticed the application to as if it were a non-standard proration unit. Is that right?
That's correct.
And also Titus did ultimately file an application for non-standard location. Is that right?
That's correct.
And they did that in an abundance of caution because a similar application had been made with the Railroad Commission. Is that right?
That's correct.
And that NSL application is currently pending pending a decision on this application. Is that correct?
Yes, that's correct.
Turning to Titus's Rebuttal Exhibit 6. This appears to be an email that just has memorializes some notes between Mr. DeLong and Mr. Lorenzo Garza. Do you see that?
Yes, I do.
And what is the date of these notes?
This is from November 10th, 2020.
And do you know who Lorenzo Garza is?
Yes, I'm not sure of his exact title, but he works with the Texas Railroad Commission. I believe he's in their permitting department.
So would it be fair to say these notes represent a memorialize a conversation between Mr. DeLong and Mr. Garza, who is with the Texas Railroad Commission?
Yes.
And so it appears from this that in early November, Titus had reached out to the Railroad Commission. Is that right?
Yes, that's correct.
We're going to skip now to Rebuttal Exhibit 12, which is at PDF 33. And if you'll turn to the end of that exhibit, which is at PDF page, I'm going to be guessing here, 33, 34, 35, I believe 36, PDF page 36. Bottom of page 35, I believe the header begins.
Yes, I see it.
So at the very bottom of the page, there's the date of this email from Mr. DeLong. Do you see that?
Yes.
And what is the date of this email?
This is January 11th, 2021.
And so going on to the next page, this is the email that Mr. DeLong sends to Mr. Garza. Can you summarize that email?
Yes, he's just updating Mr. Garza that Titus is moving ahead with permitting the multi-state lateral, that all of administrative parties have agreed in theory, and now we've been asked to send in sundries and permits so that we can begin, or they can begin working through the necessary steps to permit the well. And then he goes on to ask for some feedback as it relates to the Railroad Commission.
And so the remainder of this email chain is about some logistics about filing with the Railroad Commission. Would you agree?
Yes.
And just to kind of close the door here, taking a look now at PDF page 33, which is the first page of Rebuttal Exhibit 12. Do you see the email from Mr. DeLong to Mr. Garza dated February 22nd, 2021?
Yes, I do.
And can you briefly summarize that email for the commissioners?
Yes, he is just letting Mr. Garza know that he has submitted the Railroad Commission drilling permit that morning, that if there were any adjustments that Mr. Garza could advise. This is obviously a new project on both sides of the state line. So he's just looking for feedback from Mr. Garza as to what he has submitted and giving him some additional information on how the well is planned to be set up and the proration unit for the well.
Turning now to Titus's Rebuttal Exhibit 7, which is at PDF 18.
Okay.
And I'm looking at the beginning email there at the bottom of the page dated January 4th, 2021. Do you see that?
Yes.
And can you describe who the parties to this email are?
Yes, this is from the BLM representative, Mustafa Hop. And this is to myself and Ryan DeLong with Titus. And he has copied Kyle Paradis, who's also with the Bureau of Land Management, the BLM, as well as Christopher Walls with the BLM.
And could you summarize that email from Mr. Hawk?
Yes, sorry, go ahead.
Dated January 4th.
Yes, Mr. Hawk is following up and just summarizing the conversation that we had the previous week on a telephone call, talking about the BLM moving forward on comm agreements between states, and giving us some just further action items, such as contacting the NMOCD, the NMSLO, the Carlsbad field office, and ONRR, which is the federal government's royalty payment recipient.
And then in the email above dated a day later, Mr. DeLong follows up on this email. Is that right?
That's correct. And in that follow-up, he's just thanking Mr. Paradis for his help and making it clear that we're looking forward to working with the BLM to clear any hurdles that need to be cleared in order to proceed with the project. And at this point mentions an April 2020 spud date that we have obviously, and sorry, that actually should be April 2021. That's a typo in the email, but we did end up pushing obviously that spud date in order to try to continue working through these issues.
And were you required to get an extension for the state lease to go past that spud date?
Yes, we were.
Speaking of the state lease, can we turn now to Titus's Rebuttal Exhibit 10? And that would be at PDF page 24.
Yes.
Taking a look at the second page of Exhibit 10, this appears to be an email with Ms. Kalsa at the State Land Office dated January 13th. Do you see that?
Yes.
So this represents at least one of the initial emails between Titus and the State Land Office about this project. Is that correct?
Yes, that's correct. Do you want me to walk through it?
I'm looking, there's another email that has more of an email chain in it that's related, and just looking at my notes here, I believe we should turn now to, wait a minute. Rebuttal Exhibit 11. And you'll go 1, 2, 3, 4 pages, or actually 5 pages into that. So we're looking at PDF 30, PDF 31. At the bottom of page PDF 30, this appears to be an email between Kinda Montoya of the State Land Office and Mr. Long. Do you see that?
I do.
So Mr. DeLong has not only reached out to Ms. Kalsa, but has also reached out to Ms. Montoya. And this is on January 14th, correct?
That's correct.
And then going kind of backwards through the exhibit here, there's additional emails between Ms. Montoya, Ms. Kalsa, and Mr. DeLong, and I believe you're on some of these as well. Do you see those emails?
Yes, I do.
And at the bottom of page PDF page 29, there's an email dated January 21st, where Mr. DeLong informs Ms. Montoya that he's spoken with the division, in particular with Paul Katz, with respect to this project. Is that right?
That's correct.
And then additional emails address the request for a lease extension. And the final one is on February 1st on PDF page 27. And this is from you to Ms. Montoya. Could you please summarize that email for the commissioners?
Yes, so Ms. Montoya in her previous email on Monday, on February 1st, 2021, just asked for clarification on our request for an extension of the lease. And so I responded that on an update as to why we were requesting an extension, and reiterated that we were preparing to drill the lease in April of 2021 and ended up needing to delay that process in order to get our regulatory approvals. And that was the reason for requesting the 90-day extension.
Turning now to Titus's Rebuttal Exhibit 13. This is additional communications with Mr. Garza at the Railroad Commission. These are dated sometime in March of this year. Do you see those?
I do.
And as I understand it, Mr. DeLong had spoken with Mr. Garza about someone who had previously represented the division with respect to communications with the Railroad Commission. Do you see that?
Yes, in the March 23rd email.
And that person, who was that person who had previously communicated with the Railroad Commission about interstate wells?
Scott Dawson.
And turning to Titus's Rebuttal Exhibit 14, this is an email dated January 5th from Mr. DeLong to Scott Dawson, who now appears to be at the State Land Office. Do you see that?
Yes.
And could you just summarize that email for the commissioners as well?
Yes, so after a conversation that we had with Mr. Mustafa Haq with the BLM, he suggested that we reach out to the state land office and in particular, reach out to Mr. Dawson, and so that we could begin discussions with the state land office as to how best to proceed with our plans on drilling across the state line.
So to summarize communications that Titus has had with the interested agencies here, Titus began communicating in first part of November 10th at the latest, with both the division and with the Railroad Commission. Is that right?
Yes.
And then it appears that no later than first part of January of this year, Titus began conferring with the Bureau of Land Management and with the State Land Office. Is that accurate?
Yes.
And just to make sure we've completed our review here of all the exhibits, this is a slightly different exhibit, Rebuttal Exhibit 15. Can you explain to the commissioners what Rebuttal Exhibit 15 is?
This was an example of a memorandum of understanding, or MOU, between Louisiana, the Louisiana DNR Office of Conservation, and the Railroad Commission of Texas. It was sent to us as an example of something that's been put in place between the state of Texas and another state pertaining to wells in multiple states.
And it's your understanding that the Railroad Commission, or at least counsel for the Railroad Commission, understood that we would be entering into a similar type of MOU with respect to the proposed well here, the El Campeon 404H. Is that right?
Yes.
Let's turn now to the exhibit package and the testimony that was presented before the division. And this is tab 9 of the part 1 of 2, which was previously submitted to the commission in the exhibit packages. And it is on PDF page 61. And here, commissioners, I don't want to spend a whole lot of time on this, but I thought it would be helpful for us just to go through the basics here of what Titus is proposing. And so I would start by having Mr. Jones turn to his affidavit, which is on PDF page 68, that was submitted to the division prior to his testimony at hearing on this matter. We'll be looking at exhibits A1 through A7 that are attached to his affidavit. So to begin, let's turn to your affidavit, Mr. Jones, at paragraph 5, and just describe to the division what has been proposed here.
So we have requested approval underlying to produce from the Wolfcamp Formation, underlying the east half of section 29 and the northeast of the northeast quarter of and lot 1 of an irregular section 32 and 26 south, range 35 east of Lee County, New Mexico. Yeah, so we've requested approval of that proration unit.
And the surface hole location, the bottom hole location, the first take point, and the last take point are all within standard setbacks as set forth in New Mexico regulations, correct?
Correct.
And that's evident in paragraphs 8, 9, and 10, I believe, of your affidavit. And then paragraph 13 references the approval, the request for approval of a non-standard location here. Can you tell the commissioners who the working interest owners are in this proposed spacing unit?
On the New Mexico side, it's 100% Titus. And on the Texas side, it's 100% Oxy or Occidental.
And you have a joint operating agreement with Oxy, is that right?
That's correct.
Turning now to your exhibits here, we're looking at PDF page, we'll start with PDF page 75. And just, if you don't mind, just briefly walk through these and inform the commissioners the significance of each of these exhibits, starting with Exhibit A1.
Exhibit A1 is just a general location map showing very broadly where the project is located. So you can see it's in the far southern portion of Lee County and obviously very near the state line. Exhibit A2 is a breakdown of the working interest owners by lease or tract in the proposed proration unit. As you can see, Titus Oil and Gas has 100% of the New Mexico working interest, and Oxy USA Inc. has 100 or owns 100% of the working interest in Texas. Exhibit A3 is a blended unit ownership. So if the blended amongst the entire proration unit, shows Titus Oil and Gas to have a working interest of 82.16% and Oxy to have 17.39% in the proposed unit. And then also lists the the lease information. So it's BLM NM 12500 and State of New Mexico VB-2563. And then there are fee minerals subject to a few leases in Texas. Then Exhibit A4 is just it outlines the contract area, the working interest of the parties, and further oil and gas lease information. Exhibit A5 is a proposed or a draft C102 for the project.
And I'm going to interrupt you here, Mr. Jones, before we go on to the notice letter. And Madam Chair, if any of the commissioners have any questions at any time, it may be more expeditious for them to ask them as we go along, if you would like. If not, we'll just plug along and hopefully won't become too robotic for Ms. McFarland.
I think we'll hold our questions till the end. Thank you.
Turning now to Exhibit A6, Mr. Jones, this appears to be the notice letter that that I sent out with the application. Is that correct?
Yeah, sorry, let me pull up this. I don't know that I printed everything out.
Yeah, here now we're on PDF page 80. And really, I want to be looking at PDF page 82, which is the exhibit with those folks who were notified.
Okay. All right, almost there.
Yep.
Okay. Yes, all right, I'm there.
Okay, so Exhibit A to the notice letter on PDF page 82. And is it correct that we've notified all of the agencies who have an interest in this application?
Yes, I believe so.
Can you identify them for the commissioners, just for the record?
Yes, the In addition to Occidental as the working interest party, there's the Texas Comptroller of Public Accounts, the Railroad Commission of Texas, the Bureau of Land Management, the State Land Office of New Mexico, the New Mexico Taxation and Revenue Department. I believe that's it.
And attached further in your exhibit are green cards indicating that they all received notice, correct?
That's correct.
And the only agency who entered an appearance in the matter was the division, is that right?
Yes.
Until recently when the State Land Office entered its appearance. And then turning now to the next exhibit, which is Exhibit A7, PDF page, I believe, 83. PDF pages 83 for quite a while here. I don't have the final number PDF page, but these are all exhibits that were submitted to the Railroad Commission. Is that right?
That's correct.
And we've summarized in Titus's filings in this matter the process that Titus went through with the Texas Railroad Commission. And we'll turn shortly to the status report on that. But is it your recollection as well, which is evident in these exhibits? I don't want to walk through each one of them, but the same agencies were notified of the Railroad Commission hearing. Is that right?
That is correct.
And did any of these agencies enter an appearance in the Railroad Commission proceeding?
No, not to my knowledge.
Let's turn now to tab 17 in part 2 of 2. This is applicant status report and request for order of approval or in the alternative referral to the commission that was filed on August 18th. It is PDF page 106 of part 2 of 2. And let me know when you found it.
And Ms. Shaheen, let me make sure that I've got the right document up. Is this the document Supplemental Exhibit A9? Is that the exhibit binder? Or am I wrong? Oh, I know. My apologies, I found it.
Okay, but it does make me wonder if I should have, if we should have taken a look at supplemental.
No, just because I'm working largely on digital documents, there's moments where it takes a second to find the one I'm looking for, but I did find it and it's properly labeled. So my apologies.
Oh, no worries. But it is helpful that you pointed that out because the Supplemental Exhibit A9, which is at PDF page 3 in part 2 of 2, is the operating agreement that was executed with OCC. Is that correct, Mr. Jones?
Sorry, I was at the other page or.
Oh, sorry, because I'm going to have you go right back to the other page.
Yes, that is the operating agreement that was executed with OCC.
And it's dated May 1st, 2021, correct?
That's correct.
Okay, so then in this status report, which was filed with the division on August 18th of 2021, in part 2 of 2, PDF page 106, we provide the division with an update on the status of the operating agreement that we just looked at, Supplemental Exhibit A9. Do you see paragraph 3 there at the bottom of PDF page 106?
I do.
And then in the following page in paragraphs 4 and 5, we update the division on the status of the Railroad Commission proceeding, correct?
Yes, correct.
And we also inform the division that we've provided revisions to the pending administrative application for a non-standard location that was requested by Mr. Lowe. Do you see that, paragraph 6?
Yes.
In paragraph 7, we inform the division that we've prepared a draft MOU, which was provided to the division on July 15th. Is that correct?
That's correct.
And finally, we inform the division that this well was anticipated to be on the September drilling schedule. That's in paragraph 8. Do you see that?
Yes.
Turning now to applicant's second status report and request for approval. This is tab 21 in part 2 of 2 at PDF page 144.
Okay.
So here we've provided an update again to the division, and we've updated them on the status of the Railroad Commission proceeding. Do you see that starting in paragraph 2 and 3?
I do see that.
So can you summarize for the commissioners the status of the Railroad Commission proceeding at that time?
Yes, we were advising that on August 24th, the Railroad Commission issued a final order approving our application for a permit and accordingly an exception to one of their Rule 37 in order to drill the El Campeon 404H across the state line.
And so that final order is attached as Exhibit 3 to the status report, correct?
That's correct.
And the Railroad Commission also issued a permit, a related permit. Is that your understanding as well?
Yes, that's correct.
And that permit was also attached to the status.
Yes,
report.
as Exhibit 5.
Okay. And now you've also attached an affidavit here, your supplemental affidavit, and that's attached as Exhibit 6 to the second status report. Do you see that? And here we're on, let's see, do I have a PDF page number for this one? Apparently I do not. But if I make a guess, I'm going to guess it's around PDF page 170. Somewhere in that vicinity.
Yeah, let me get there.
I imagine if you do a search for supplemental affidavit, it'll pop right up. So as I understand it, this affidavit was presented to inform the division about your communications with other states and other operators in which interstate wells have previously been drilled. Is that correct?
Yes.
Okay. So the division asked.
Just for the benefit, I guess, of the other parties, I believe it starts on page 168.
Thank you, Mr. Jones. So can you briefly describe the history of the division requesting information about other interstate wells and your investigation into that?
Yes, just in conversations with representatives from the division, they had asked us to see if we could find other examples. And so frankly, most of my career has been spent working in New Mexico and Texas. And obviously, this is not something that there are a lot of examples of there. So I began to look around the country and call other people that work in different areas. Obviously, with in the last couple of decades, there have been a lot more horizontal wells, which doesn't really, it doesn't care about, geology doesn't care what state it's in, I guess. So I looked at other states that had fields that were near state lines and just started looking at wells and trying to gather whatever information I could. And again, all of this was at the request of the division and ended up finding a couple examples and reaching out to some of the interested parties, whether that be the regulatory bodies and or the companies, and just trying to see who I could get in touch or have the division reach out to if they wanted to reach out to someone.
And so in your supplemental affidavit, you provided the names of someone in the West Virginia Department of Environmental Protection Office of Oil and Gas. Is that right?
That's correct.
And then you provided the name of, let's see, of someone employed by the Pennsylvania Oil and Gas Management Section. Is that right?
That's correct.
And you also obtained an MOU between the West Virginia Department of Oil and Gas and the operator of the well. Is that right? Attached as Exhibit A, I believe it's PDF page 172.
Yes, that is correct. That was as part of my conversations with the representative from West Virginia. He said that was the way that they generally handle these types of wells, and he was nice enough to pass along a memorandum of understanding between West Virginia Department of Environmental Protection and the operator, which was EQT Production Company.
And then there's also a permit that's attached as Exhibit B, a few pages in. Do you see that?
Yes.
And can you explain to the commissioners what that well permit is?
Yes, this is an approved permit from Pennsylvania of a well that crossed the state line of West Virginia and Pennsylvania, having a surface location in Pennsylvania.
And turning to the very next page, Exhibit C, this is a map that illustrates the location of that particular well. Is that correct?
That's correct. That was a map that we put together by using the XY coordinates provided by the operator in their permit.
And can you just summarize for the commissioners what you learned when you spoke to these folks in West Virginia and Pennsylvania about interstate wells?
Yes, it was seemed rather straightforward. The general consensus was that the surface operator or the location of the surface location is what we control, in that particularly in West Virginia, their main concerns were addressed through an MOU between the operator and the state. And Pennsylvania did mention that they had conversations, maybe at a higher level than who I spoke with, about entering into some sort of MOU between the states of Pennsylvania and West Virginia, but they weren't waiting on that in order to proceed with the permitting of wells across state lines.
And when you spoke with them, did either of them note a particular problem that was arising from interstate wells between those two states?
No, they did not mention any problems that they'd had.
And do you know whether the division ever followed up with either of these folks?
I'm not sure.
Mr. Jones, at this time, do you have anything else in addition that you think would be helpful for the commissioners to hear from you before I pass you as a witness?
Yeah, I think my only sort of thought is there have been some suggestions as though we could go somewhere else, not work on this project. And I know that often the commission hears from larger companies that are often public companies. We are a private oil and gas operator. We do not have a large footprint of acreage and places that we can go to run our business. And so that is the reason that we tried to wait, we tried to delay, we tried to work with everyone for months and months. And we just simply, we were not trying to do anything to upset the division, upset anyone. We've been trying to work very hard to work with all of the regulatory bodies. And we simply just can't wait because, again, we don't have a lot of places to go. And so in order for us to continue to operate our business, we've had to drill these wells and satisfy obligations. And I just wanted to put that out there that we are happy to work with everyone. We want to work with the Railroad Commission and the division and the commission and the state land office to see this happen. We think it's a unique idea and a unique project that we believe is beneficial for all parties. And we appreciate all of your time in working on this.
And you've agreed, Titus has agreed to comply with all New Mexico regulations with respect to this well. Is that right?
Yes, absolutely.
And to your knowledge, has Texas questioned the fact that Titus is prepared to comply with all of the New Mexico regulations?
No, they have not.
I pass the witness. Thank you, Mr. Jones.
Thanks.
Mr. Tremaine, do you have questions for the witness?
I do have a few questions. Thank you, Madam Chair. Good morning, Mr. Jones. Thank you for your time. I just have a few questions for you. Mr. Jones, you understand that the other states you've referenced have both different enabling statutes related to oil and gas and different regulatory structures from the state of New Mexico, correct?
Yes. I don't understand. I definitely don't have a robust understanding of the structures of their regulatory bodies, but I do understand that they are different than New Mexico.
Thank
and
you.
Just for the record, to the extent that Mr. Tremaine is asking Mr. Jones to opine on a legal issue here, I would object to that.
I didn't ask for his legal opinion. Mr. Jones, you understand that it's consistently been OCD's position that an MOU or any other written agreement would be between the OCD and the Railroad Commission, correct?
Yes.
In fact, the division informed Titus that an MOU would be necessary prior to drilling into Texas, correct?
Yes.
And Mr. Jones, you understand that the Railroad Commission in its hearing actually referenced the likely need of an MOU between the parties, correct?
They referenced that originally in our conversations, but then went on to approve the permit, and in our subsequent conversations made it clear that that permit is approved, drilling could take place on that permit, and that it was their desire, though not requirement, for future permits to have an MOU.
Okay, so generally the Railroad Commission's position, as you understand it, was that an MOU is necessary, but it was not referenced as necessary in the final order from the Railroad Commission?
Objection
for this one.
Yeah, that's not my understanding. My understanding.
Do we have an, sorry,
Wait.
Mr. Jones, was there an objection there?
I'm not sure what the objection was to. Do you want to repeat that, Ms. Shaheen?
Yes, the objection was to the form of the question, and I believe it misstates Mr. Jones's previous answer. So that would be my objection.
It was a compound question. I'll just rephrase.
Thanks.
So, Mr. Jones, if I understand you correctly, your understanding is that the Railroad Commission feels an MOU is necessary for future wells?
No, not necessary. That's something that they would like to have in place, but from my conversations with the Railroad Commission in this very particular area on this particular project, they have not communicated that it's necessary to have a memorandum of understanding prior to approval of future permits.
Okay, so your answer is that Railroad Commission would like an MOU.
That, yes, that's my understanding.
Mr. Jones, you understand that Mr. Powell is the Engineering Bureau Chief for the Oil Conservation Division, correct?
Yeah, I probably don't know his title off the top of my head, but if that's what he is, I don't disagree.
Okay. And do you understand that Mr. Powell indicated in April to Titus that your proposal for the interstate well was under review?
Yes.
Okay. In fact, do you agree that Mr. Powell and Mr. DeLong were communicating by email in April, in fact, April 15th, is that correct?
I will take your word for it. I'm sure that that's accurate.
Okay. And you do understand that Mr. Powell never indicated that the well would be approved absent an MOU, correct?
Yeah, not as I recall.
And you are aware that approximately 2 weeks after that discussion, in the middle of April, that the OCD entered its appearance and notice of intervention on April 29th?
Yes.
So it's fair to say that Titus understood that the Oil Conservation Division had some concerns to be addressed and wanted an MOU in April of 2021, correct?
Yes, I believe so. Though I do think the concept was initially introduced by the Railroad Commission, if I remember correctly, but which obviously they changed their mind on its necessity.
Thank you. The examples that you've referenced of wells from other states, when were you communicating about with the Oil Conservation Division about those other interstate wells? Sorry, do you understand my question?
Yeah, I think like when was the division made aware of those other wells or?
Right. Well, I believe that you had indicated that you attempted to provide examples of other interstate wells after discussions with the Oil Conservation Division.
Objection form.
I'm simply trying to clarify the question.
Right, but you phrased it as he attempted to. Well, he did inform the division. That's my objection.
Yeah, I believe.
Jermaine, will you rephrase that?
When did you provide examples of other interstate wells to the Oil Conservation Division?
I believe that it would have been by way of my supplemental affidavit that we talked through earlier. I can't remember exactly what day. It looks like it was, I signed it on September 1st of 2021.
Okay, thank you. And Mr. Jones, do you agree that the other cross-border wells that have been discussed do not commingle resources from two separate states?
I don't believe I don't think that's true. I believe that they are drilled and produced from both from each state, West Virginia and Pennsylvania.
So your testimony is that those, the wells from, sorry, you said it's two states. Please, could you please reiterate the two states?
West Virginia and Pennsylvania.
Okay. So are you saying that the West Virginia and Pennsylvania cross-border wells produce minerals from both West Virginia and Pennsylvania?
I believe so. That was I didn't verify that, but that was something that I had through conversation with the representatives of those governing body or those regulatory bodies. I explained what we were doing and asked for examples of that. And so that's why they sent me that information, but I did not go and verify that independently.
Are you aware of the well referenced in filings in this case that with the wellhead location in Texas and a lateral that extends into New Mexico?
Yes.
Okay. And are you aware of the fact that that well does not produce Texas minerals?
Yes, I am aware of that.
Okay. And do you understand that the tank battery and facilities associated with that production are located in New Mexico?
I don't believe that I'm explicitly aware of that, but again, if that's what you're telling me, I imagine it's true.
Thank you. I just wanted to clarify quickly about Titus's plans for future development. It's true, Mr. Jones, that if Titus is able to proceed with this interstate well, that it may pursue as many as 40 or more other wells that cross the New Mexico and Texas boundary. Is that correct?
Yes, it could be.
Okay. And assuming everything went well with this particular Campion well, and there was an MOU, or forget the MOU, assuming everything went well with this particular well, what's Titus's timeline for pursuing those other 40 wells?
Gosh, that's probably a tough question, but I would imagine within the next 2 years or something. It's frankly hard. I think the outcome of this hearing has a bearing on the economic viability of a lot of those 40 possible future wells. So it's hard to know the timing. I do think if we were able to cross the state line, that this would be developed sooner rather than later.
Okay. And does Titus have a currently proposed spud date for the next of those potentially 40 wells?
I'm trying, I can see if I can pull a rig schedule up. This is it's always change. It's a living document, but I actually can't find it, but I believe if we're we're coming up on October. I mean, I think we would like to be able to proceed with future state line crossing wells, Q1 of 2022, something like that.
Okay, so it sounds like if the commission approves Titus's plan to move forward with this cross-border well, that Titus could be looking at the next cross-border well between January and March of 2022?
Yes, and again, I'm kind of shooting from the hip a little bit.
I understand. Thank you. I don't believe I have any other questions. Thank you for your time, Mr. Jones.
Thanks.
Thanks. Let's see. Mr. Klonsich, do you have any questions?
Good morning, Madam Commissioner. Before I launch into question, we may not have to.
Sorry, I'm having trouble hearing you.
Can you hear me better?
Yes.
Okay, this is an external microphone speaker. I'd like to ask a question of Ms. Shaheen. did she hear the proposal and the stipulation that I communicated on open? And does she agree to that? If so, I don't have to ask any questions.
Yes, I believe that you accurately represented the agreement between Titus and the State Land Office. And I understand that we've agreed on the most recent drafts that were circulated with respect to the stipulation between Titus and the State Land Office, and also with respect to the draft MOU that would be attached as an exhibit to that stipulation.
She put that more eloquently than I could. No questions then.
Mr. Feldowart?
Thank you, Madam Chair. Mr. Jones, I just have a couple quick questions. I believe you testified that Titus does not own an interest in that tract on the Texas side.
That's correct. We have a JOA that governs there.
Okay. But you don't have an ownership in the underlying minerals on that Texas acreage.
That's correct.
Which explains then why you would not be proposing development on the Texas side with other interest owners on the Texas side.
No, I think they're just existing wells offsetting that tract.
Okay.
Yeah, and obviously we if we don't have any interest, we can't drill a well, but yeah.
That's what I was trying to get to. Okay, I got it. Okay, thank you very much.
Yes, sir. Yes, sir.
Mr. Rodriguez?
No questions, Madam Chair.
Commissioners, do you have any questions for the witness? Or Mr. Warnell or Mr. Baca?
Madam Chair, I have a question for Mr. Jones.
Go ahead.
Mr. Jones, do you know the age of the wells that are crossing the state lines in West Virginia and Pennsylvania?
I don't know off the top of my head, but I do distinctly remember that they were in the last 2 or 3 years. So there are recent wells there.
And so when you say that there's been no problems with them in your statement, that's within the last 2 or 3 years. So they really haven't gone through an audit function or any kind of long-term disbursement of royalties.
I guess not long-term. They've certainly established production and established the payment of royalties and likely been audited. Our company is a small company and we're audited every year.
And I guess audited from a royalty standpoint, both federal and state, and West Virginia and Pennsylvania.
Okay, yeah, I can't speak to.
Okay. That's the only question I have. Thank you.
Thanks.
Madam Chair, Commissioner Warnell, I have a couple questions for Mr. Jones. Good morning, Mr. Jones. Thank you for being here today. I think I remember reading someplace that in Titus's paperwork that the acreage in New Mexico for this particular well, the 404H, excuse me, well has about 280 acres of New Mexico acreage, but I never saw anything. I don't recall seeing anything about the acreage involved with this particular well in Texas. Do you know what that would be?
Yes, I should know off the top of my head, but I just don't want to tell you the wrong thing here. It's actually part of the JOA. Let me do some quick math here and So it's roughly, or it's 49.2 net acres in Texas.
So what would that be? 20% or something like that, I guess, of the total acreage. Mr. Jones, has the 404H well been drilled?
Yeah, so it has been, I believe Ms. Shaheen kind of started to explain this, but the way that we often develop is by pad drilling. And so in order to maximize surface and really traffic and safety, we will often drill the vertical portion of multiple wells, and then come back and drill the intermediate and so on and so forth of each well in subsequent order. So I do believe that the vertical portion only of the 404H has been drilled as part of our pad drilling process, but frankly, we can stop at the state line or continue. We've designed the well in a manner that would be safe to continue into Texas.
Okay, so if you drilled the vertical portion, have you made your radius and turn and gone laterally?
I do not believe we have, no, sir.
Okay. That's all the questions I have at this time. Thank you, Mr. Jones.
Thank you.
I think most of my questions have been answered at this point. So just to confirm, originally Ms. Shaheen had talked about the October 1st date. Is that still on the table?
Yeah, so I think we probably, as far as a go, no-go day, we've had to adjust our drill schedule because there's an offset completion. So I think it's probably given us another week. So we can call that October 8th. So we're not the operator of the offsetting wells, but we have to basically adjust our drilling plans accordingly so that we're not, we're being safe in how we drill these wells. So I think it's more of a October 8th day.
Okay. And so basically you need indication by October 8th as to what the drill plan is.
Yes.
And so what, in your mind, made it necessary to sort of move forward with drilling this pad during this time frame?
Yeah, the most pressing matter was the expiring New Mexico State Land Office lease. So we did have conversations about extending that lease, but we never got to a final number or what that could potentially look like, but it was what we felt like was a significant amount of money that we would have had to spend to extend the lease further. And again, as we've had these conversations over the past almost year, we couldn't continue to delay our operations and really the broader company plans.
So you made a business decision to move forward with this drilling plan even after the OCD communicated to you that there should be an MOA in place prior?
Definitely did not make the decision to drill across the state line. So, that's something that is not something we are currently planning to do because that has not been approved by the OCD. So, but we did feel like drilling the well and stopping in New Mexico was something that we needed to do as part of our broader drilling plans for our company. Yes, ma'am.
So drilling the well to New Mexico and not across the border was a better decision than extending the lease?
I think based on our experience, it is undetermined still when a memorandum of understanding is going to be entered into. And the actions that we have seen or not seen or have made it very unclear. And so if we knew a day that a memorandum of understanding was entered into, that we could extend the lease and spend potentially hundreds of thousands of dollars to do so, that is a decision that we could have made with all of that information. But the only information we had was we tried to have this conversation for almost a year. We sent draft MOUs and have not been terribly encouraged by just, we don't know when it's going to happen. And so it did not feel like there's a hard date that we were aiming for.
So in lieu of that, you just decided to move forward. Correct.
That's correct.
Okay. I have no further questions. Ms. Shaheen, do you have any redirect?
Madam Chair, I've got a question.
Go ahead.
I want to clarify this because I think I may have misheard Mr. Jones' testimony just a minute ago. So there was discussion about circumstances that resulted in a line not crossing state lines, and I wasn't clear. Mr. Jones, if this permit were to be granted by the commission, then it's the intention of Titus to basically connect the New Mexico and Texas parcels, right, for purposes of the drilling?
Yes, so we would drill from our surface location in New Mexico to a bottom hole location in Texas.
Okay, I just wanted to clarify that. Thank you.
Yes, sir.
Ms. Shaheen, do you have any redirect for your witness?
Yes, briefly, Madam Chair. Mr. Jones, with respect to your to the questions that Mr. Tremaine posed to you, you were first informed that a MOU would be required by division counsel, correct? In other words, Mr. Powell didn't inform you that an MOU would be necessary, did he?
Not that I recall, but frankly, yeah, I'm not sure exactly who said what. Obviously, we spoke to multiple representatives over many months.
And so to your knowledge, Mr. Katz didn't inform you that an MOU would be necessary, did he?
That's correct, not to my knowledge.
Mr. Sanchez didn't inform you that an MOU would be necessary, is that right?
That's right.
And to your knowledge, Mr. Powell didn't inform you that an MOU would be necessary, did he?
That's correct.
And is it your understanding that the purpose of the MOU is to guide the agencies, the Oil Conservation Division Commission and the Texas Railroad Commission, with respect to wells, similar wells in the future? In other words, it's not your understanding that the MOU is necessary for this particular well, the El Campeon 404H. It's just to allow the parties to move forward without all of these hearings going on for each well that Titus may propose in the future. Is that right?
Yes.
And Mr. Tremaine also asked you about when you first provided examples of interstate wells. Do you remember that testimony?
Yes, I did.
And you referred to the second status report, right? When you provided the MOU between West Virginia and the operator and the permit from Pennsylvania, correct?
Correct.
Prior to that time, though, you had provided additional previous information about interstate wells that you had acquired from Drilling Info. Do you recall that?
Yes, I do.
And if I remember correctly, it was sometime first part of June when we provided that information to the division. Do you have a similar recollection?
Yes, I agree. I believe I sent the information to you so that you could then pass along to counsel with the division.
And do you recall what the division counsel's response was with respect to that information that you provided from Drilling Info?
Believe it was something along the lines of needing additional information or some sort of publicly available repository for that information. Maybe a website or just something that they could refer to that was not Drilling Info, which I had a very difficult time tracking down.
So would it be fair to say that your understanding was the division didn't have access to Drilling Info and so did not want to rely on that information? Would that be a fair summary of your understanding?
Yes.
I believe that's it for my redirect. Thank you, Madam Chair.
So at this point, we've been going a little under 2 hours. Ms. McFarland, I guess question for you. Would you like to take a break now? Or do you want to push a little bit longer and then take a lunch break? I think you're muted if you're trying to
Yeah,
speak.
sorry, no, I'm on this one computer, so I have to flip back and forth, and sometimes the button doesn't work. What are we at now? We're at 11:14?
Yeah.
If we could take a lunch break around 12, I could probably push through.
Okay. All right. I guess then Mr. Tremaine, or I'm sorry, Ms. Shaheen, do you have any additional witnesses?
Madam Chair, I'm happy for us to provide the geologist and the engineer if the division has any questions. As I mentioned before, I don't believe that the division challenges the technical aspects here. The formation on the New Mexico side is the same as the formation on the Texas side. So if anyone has any questions about that, we can provide them for cross-examination, but otherwise, I don't know that I need to waste anyone's time with presenting their testimony. Again, it is in their affidavits that were submitted and it's also in their testimony before the division in the transcripts that were previously provided.
Just to confirm, are there any parties that have concerns about not presenting those witnesses?
No concerns from the division.
Commissioners, do you have any need for Titus to present those witnesses?
I don't believe so, Madam Commissioner.
And Madam Chair, because we've got the submission, essentially the record below, you can take judicial notice of those things at this point if you wanted. So that way they're incorporated into the record, and unless there are questions, which it doesn't sound like there are, that would stand.
Okay. All right, that sounds good then. Ms. Shaheen, I don't think it's necessary to put them on as witnesses at this point. But we do, as Mr. Melander said, have the records from the division hearing, as this was not a de novo case.
And Madam Chair, are you taking judicial notice of that record for purposes of evidence in this hearing?
We're taking judicial notice of that record as purpose for evidence in this hearing.
Excellent. Thank you.
Thanks. All right, Mr. Tremaine, you're up.
Right. Well, the division has one witness, Ms. Tiffany Pollock.
Ms. Bullock, are you with us? Yes.
I am here.
Let's see, Ms. McFarland, would you administer the oath, please?
Yes, Ms. Polk, would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Good morning, Ms. Pollock. Could you please state and spell your name for the record?
Good morning. Tiffany Pollock, Tiffany. Last name P as in Paul, Olak.
Ms. Pollock, on whose behalf are you testifying today?
Energy, Minerals, Natural Resources, Oil Conservation Division.
And are you testifying today as a fact witness?
I am.
Please provide a brief summary of your education and experience.
Sure. I have a Bachelor of Science in Professional Zoology from the University of Oklahoma, a Master's of Infectious Disease Control Epidemiology from University of Texas Houston Medical Center. I then somehow ended up in oil and gas and chose to obtain a Master's of Petroleum Engineering from Texas A&M. I then spent almost 25 years working various oil and gas basins, plays, various mid-size operators. Worked the past 10 years in unconventional shale plays, mainly focused on development. And then for something wildly different, decided to join the state as the deputy director in April 2020.
Okay, and so your current position with the Oil Conservation Division is as deputy director?
I am, yes.
And could you please describe for the commissioners and parties how that position relates to this particular proposed interstate well?
Sure. So I'm the deputy director of, and under my charge are the environmental and engineering bureaus. And the engineering bureau is charged with the approval at a high level, the approval and denial of well permits. Both the bureaus, engineering and environmental, are charged with, again, high level proper regulation of the wells and the well sites throughout life.
The engineering and the environmental bureaus would be responsible for regulating if anything went wrong with drilling the well?
Correct.
Or approving casing and design specifications?
Yes.
And if there was any release associated with the well?
Yes.
The engineering division would be the division responsible for working with their counterparts at the Railroad Commission to deal with any issues that come up related to an interstate well. Is that fair to say?
That is correct. I imagine environmental could have some say as well with regard to any type of release, reporting, and or remediation that we would need to work out as part of that MOU.
Okay. Are you generally aware of the Campion 404 well proposed by Titus?
Yes.
Okay. And are you aware of communications between the Oil Conservation Division and Titus regarding the proposed Campion well?
Yes.
Okay. Please describe the communications between the division and Titus.
Sure. So my awareness began about in March. I've heard testimony today about ongoing communications prior to that. However, the engineering department did not come under my leadership until earlier this year. So it was around the March timeframe that I started becoming aware of more of the details around the project. Beyond that, it was around April, May when I'm aware that council was having conversations with Titus to take OCD's position that we wanted the MOU in place before any development activity occurred.
Thank you. Could you, are you aware generally, strike that. Could you provide an update on the current state of any possible agreement between the Oil Conservation Division and the Railroad Commission?
Sure. So those conversations are still ongoing, mainly between council, between the two divisions. The technical staff is working the issue from our end and understanding different regulation details. But based on where the current discussions are now that are ongoing, I am expecting that there'll be an updated draft for management review.
Okay. As a general matter, does OCD approve of interstate development such as what is proposed by Titus?
Yes.
Okay. I want to ask you a couple questions about waste. Titus's applications and filings discuss the prevention of waste. And in this particular matter, when we're talking about within New Mexico, we're talking about the setbacks. So please describe your understanding of the purpose of setbacks.
So setbacks are put in place to maximize the resource produced from the defined lease and prevent any type of drainage from outside the defined lease.
Okay. So in regards to the 100-foot setback within New Mexico with this proposed well, what's OCD's perspective regarding the characterization of that setback as waste at the Texas border?
So the 100-foot setback is set forth in rule, and I'm terrible with remembering names and numbers of these rules, so I wrote it down. It is 1915-16-15 C1B, and that is where the 100-foot setback is defined. Our perspective on that is that, again, this is the minimum distance that the state deems would protect us from drainage outside the defined lease, and that maximum footage that we could gain off the lateral to capture the most resources and prevent waste. So in our minds, the 100-foot setback does not allow for waste.
Approximately how many wells does OCD permit to drill each year?
Well, it depends on the year, but I would a couple thousand in general.
And does the setback that we've discussed apply to those other wells?
Yes.
And in the context of those other wells, are those setbacks considered waste?
No.
Can you provide any background on the other interstate wells that have been discussed? What has been approved and what is not?
You know, I can't speak to the details or names, specifics of any of the wells, but what I can tell you is from the discussions with staff around this proposal in general is that we don't have any wells currently approved that are that commingle production. So they were either, any that have been approved were either drilled from one state or the other and producing from one state or the other.
Okay. What are the foreseeable issues that OCD believes necessitate an agreement between New Mexico and Texas prior to either completion or production of the Campion well?
Well, I think first and foremost is that allocation agreement. Right now, without an MOU in place, we don't have a regulatory mechanism for allocation of that production. I think then there's a slew of things that can happen with the development of well, different regulations that each state has that needs to be explored. And so some of these were referenced, again, generally speaking, in our pre-hearing statement around venting and flaring and gas capture and spills and releases and reporting. And those are very general topics. I understand that. Well design, casing, they're general, but I think that each of those things has to be discussed because we admit that all of all of these states, Texas and New Mexico specific in this one, have very different regulation requirements and expectations of a well producing. So we want to explore those things, understand how we're going to agree to those things, and make sure that we have agreement in place before those things occur.
How does proceeding without a written agreement impact OCD's ability to do its job?
Well, so again, going back to states have different statutory obligations and regulatory requirements. Without any type of agreement on how those differences would be handled, it's our belief that OCD cannot ensure that we could fulfill our obligations statutorily or regulatory to prevent waste, protect rights, the environment, unless we have that agreement in place.
Do you believe that it is settled or established that that Texas minerals would be subject to New Mexico rule if they were accessed through a New Mexico wellhead?
I don't believe that any formal agreement has been made.
Okay. Does OCD have any concerns about relinquishing New Mexico minerals to other states' regulations if those minerals are accessed through a well located in the other state?
Yes.
I want to ask you some questions about the specific design and proposal put forth by Titus. As having had the opportunity to review the proposal and hearing Titus's presentation, what is OCD's proposal for what could or should be approved prior to an agreement being put in place between New Mexico and Texas?
So the OCD would have preferred for all of the development activity to hold until an MOU in place, and I believe we communicated that. As it stands, I understand that the vertical portion of that well has been drilled and not yet the horizontal. Given that the OCD doesn't disagree technically, and we do support interstate development, if the commission were to approve the application contingent on an MOU, OCD could get behind supporting no further development activity beyond drilling of the lateral until an MOU is in place. But again, as OCD has stated before, we would have preferred an MOU in place prior to any development activity. We do understand the situation that we're in right now, and could, again, get behind a contingent approval based off an MOU with no prior or no additional development activity. It was probably way confusing, but
Well, to clarify, is it fair to say that if the commission approved the well contingent upon execution of an agreement between New Mexico and Texas, that the stopping point would be at drilling the lateral prior to perforation?
That is correct.
Okay.
And I would also,
OCD,
I would also add that that would also be contingent upon the division, and I'm not going to speak for the Railroad Commission, but looking at the well designs, the casing, et cetera, the drilling design of those wells, the well design before they continue drilling.
Great, thank you. Does OCD have any concerns about allowing completion or perforation of the lateral contingent upon an executed agreement?
Yes.
Can you describe generally what those concerns are?
Sure. Again, generally speaking, the further we go into any kind of development activity, the more risk we have for the differing differing regulations of each state to compete with each other without agreement. So completion is very complicated, as you know. It requires certain designs, certain operational activities, and the OCD would prefer to have an MOU in place on how any mitigation for any type of emergency, a design flaw, operational issue would be handled prior to that activity happening.
Is the division, in your opinion, diligently pursuing an agreement with Texas?
Yes.
Okay. If Titus were, strike that, can the division guarantee execution of a written agreement with Texas by any date certain?
No.
If Titus were allowed to complete the well, but not produce from the well, could the resource be impacted in any way by the delay between completion and execution of an agreement between New Mexico and Texas?
Potentially, yes.
Okay. One moment. So is it fair to say that the division's position is first that drilling activities across state lines should not commence prior to execution of a written agreement?
Correct.
Okay. Is it also fair to say that in the alternative, if the commission wishes to proceed with contingently approving the Titus's application, that the OCD's recommendation is that the activity only be allowed to finish drilling but not complete the well?
Yes.
Okay. And is it also fair to say that, you know, OCD, as it cannot guarantee execution of a written agreement, that there is no guarantee that an agreement will actually take place?
There is no guarantee, but the OCD has a vested interest in trying to create that agreement with Texas because we do envision bigger projects than just Titus. There are other developers in the area across the interstate boundaries, and we would like to get those agreements in place ahead of time to be able to approve and forward that development.
Okay. No further questions.
Thanks, Mr. Tremaine. Ms. Shaheen, do you have any questions for the witness?
I do. Ms. Pollock, it's nice to meet you virtually.
Nice to meet you, Ms. Shaheen.
Hopefully, in person, we'll get to meet at some point.
Fingers.
Yes. So I did have some questions prepared, but I think what I want to start with is asking you questions about your direct testimony so far. Mr. Tremaine asked you about the communications between the division and Titus. Were you actively communicating with Titus at all at any point since the application has been filed?
No, communications were mainly handled by counsel at the point in time when I got involved.
Okay. And you said you became aware in April, May that OCD counsel was taking the position that the MOU is required. Did I understand that correctly?
OCD began taking that position, and those were conversations I was in with counsel in which OCD took that position. And it's my understanding that counsel then began communicating that with Titus.
Okay. And is there someone in particular who raised the concern about the need for an MOU with respect to wells other than the El Campeon 404H?
Well, I mean, it's a group of us, it's a team. The council involved was Eric Ames, which I'm sure you are all aware. And then I have Bureau Chiefs, Brandon Powell, who we've mentioned here. Emily Hernandez is our Environmental Bureau Chief. And so I can specifically talk to, again, this has been focused so far mainly on the engineering side, so Brandon Powell's group, because of the need for the approval of the permit. So is there someone specific? I wouldn't point to anyone specific. It was general conversations around how are we going to handle this and what do we need in place, because this is much bigger than just one well.
And excuse me, you're aware that there's already an approved BLM permit, correct?
I believe I'm aware of that.
And just to be clear, the approved BLM permit applies to the New Mexico portion of the well.
That's correct.
But what I understand is that BLM has informed Titus that all they need to do is file a sundry to extend the well into Texas. Are you aware of that?
I'm not aware of those conversations. I was aware that BLM had been engaged. And so my caution to you guys and to anyone would be make sure you've got all of the ducks in a row with BLM before proceeding. So if you say that, I believe you.
And did the division have any communications with BLM about this application?
I personally did not. We generally are in great communication with the BLM on things where we cross jurisdiction. I can't say specifically who or when or whether they communicated.
Do you know when the division first communicated with the state land office about the application?
I do not.
Can you provide us some specifics about communication between the division and the Texas Railroad Commission about the application?
When those conversations started coming up in the March, April timeframe, and thereafter it would be sometime after April and before June, I believe, but I could not cite a specific date.
And do you know who would have communicated with the Texas Railroad Commission at that time?
So I think at this point it would have been mainly council. I think there was some technical staff conversations that were going on, but at this point it's mainly council between both the states.
And do you know who among technical staff communicated with the Railroad Commission?
I don't.
But it's your testimony that someone from technical staff communicated with the Railroad Commission. Is that right?
I cannot say that for certain. It would be my thought that upon the legal conversations going on, that technical staff would be involved at some level. Whether or not they had the actual technical staff had specific meetings or not, I cannot say that. The level that I communicate with on the status updates of those meetings, it's not necessary always that I know the exact who's and when's and what's, just that what are the next steps and who's engaged in those conversations and where are we moving towards. And so I can tell you that the lead of those conversations thus far has been legal counsel.
And do you know how many times legal counsel has conferred with the Railroad Commission counsel about this application?
I do not.
Would you say it's once or between one time and 3 times? Do you have any idea?
Given the status updates that I've been given, I would say more than once. I couldn't tell you how many thereafter.
So you mentioned that this technical staff, engineering, and I've lost my engineering and environmental have concerns. And so I have 2 questions for you in that regard. One is, do those concerns relate to this particular well?
If we're going to commingle production, yes.
And can you tell me what those specific concerns are about commingling of production?
Well, okay, so let's back up. If we're going to drill a lateral through 2 states, there's multiple concerns, the first of which is the commingling. How are we going to allocate that production? How does the gas capture happen? We do have new gas capture requirements. Are we going to abide by those, or are we going to abide by Texas? So there are portions of Texas's production. I mean, these are all questions that you ask, right? With regard to the commingling aspect. And then I think beyond that, it becomes about a lateral located in 2 different states. It could be anything from who and when do inspectors from each state, are they allowed to inspect those wells? If there's a problem, are each state's required to give the information on that inspection, on those inspection reports, and any issue we may have? Are the states required to give that to each other? I mean, the list is endless. The bottom line here is that if you put a lateral in 2 different states and we're commingling the production, we have to talk about the regulatory differences in the 2 states and how we're going to resolve that.
So let me ask you this. If Titus is required to comply with all New Mexico regulations, why does it matter that Texas has a different regulation?
Well, I would say that that's particularly good for New Mexico in that one particular case, but I would like to continue conversations with Texas about that, because let's pretend it's the reverse. I'm not sure that New Mexico agrees that commingled production between New Mexico and Texas drilled from the Texas side should only have to abide by Texas regulations. So
Well,
again, this is about bigger than this one well. So New Mexico wants to have that conversation with Texas.
Well, with all due respect, this application pending now before the commission is about drilling from New Mexico and Texas. And Titus has represented that it is only drilling from New Mexico and Texas. So I guess I'm having a hard time wrapping my head around why the division feels like it needs to address something that is not even before the division and not before the commission at this time. So maybe you can elaborate a little bit on that.
I understand. So first of all, I'll just remind that it isn't, you're proposing this one well in this one case, but you do have plans for a bigger, broader development. I'd also say that Texas has expressed in conversations with us and in testimony that they wish to have an MOU as well. Now, I did hear prior testimony that they backed off the necessity of that, but in conversations that we've had with Texas, it is their preference to have an MOU in place for broader developments.
And so two points I want to ask you about. One is, first of all, you understand that Titus's proposed development plan for future interstate wells is only from New Mexico to Texas. You understand that, right?
I do, but I also understand that there are other developments that are being contemplated that aren't structured specifically in that way.
And can you
Not
tell
with
us
Titus. Well, again, I'll go back to, and I know I don't expect Titus to care about this. I once worked operations, so I understand your vested interest is to your company, but our vested interest is in the broader development of New Mexico. And so it's not just Titus who is looking at interstate development. And so if we're going to put something as big as an agreement between New Mexico and Texas in place, we'd like that to be in place prior to any of those other developments. It's bigger than just this well, is all I can say.
So you've mentioned a couple of times that there are other interstate developments that are out there. Can you provide us with information about those existing development plans and who the operators are?
Not out there, but I think there's great interest. And I think because of the complexity of this is what has slowed it to this state. I mean, there's one operator being represented that's an appearing party here today that has potentially some interest in development at some point from what I heard earlier. But I'm not going to go through and list all of the other operators and their own company plans.
Wouldn't you agree that that bridge should be crossed by that operator who proposes to drill from Texas into New Mexico, and that burden should not be imposed on an applicant who's not even seeking to do that?
But Titus is seeking to put a lateral across 2 states, for which both states have agreed would like the MOU in place first.
with all due respect, you did hear testimony earlier that we have permit, we have approval to drill into Texas. So Texas is not requiring an MOU. It's for this particular well. You're aware of that, correct?
I understand that Texas backed off their stance of the necessity. I also understand from our conversations that they still want to proceed with an MOU.
I got a little off track here. Let me see if I can get back to where I was. So you said that the concerns by engineering and by environmental are about commingling and how production is allocated. So are you aware that Titus has proposed in this application to allocate production on the same basis that every other well in New Mexico is allocated production on surface acreage? Are you aware of that?
Okay, first let me back up at the start of that statement. I think I said in my testimony, and I can clarify here, that was one of the concerns, not the concern. Is let's start with just the commingling of production. It's the most obvious. I am aware that there have been some proposals around how the allocation of the well should occur. It is my understanding that we have not yet come to any formal agreement on that. It has not been put forth to me or the director of our division for approval.
My understanding is that Titus is asking for approval to allocate production based on surface acreage. Is that not your understanding?
That's what I've been told. I'm just saying that has not yet been approved yet. And we also don't have any formal agreement with Texas on that, to the best of my understanding.
It makes me want to take a look at the order, because the Texas order does say that production can be allocated either by surface acreage or by perforations. And Texas doesn't care. Either one of those is fine with Texas. So because New Mexico regularly allocates production based on surface acreage, and because Texas has agreed that the allocation can be, the production can be allocated based on surface acreage, is there still an issue in your mind about how allocation of production should occur?
There isn't necessarily an issue. I just don't know that we have formally decided, and that is also not the only thing to consider with regard to this development. It is one of them. It is, like I said, the most obvious one. I don't know that there's an issue. I just know that in my mind, there has not been formal agreement between the two states on this.
Would it be helpful if I found that order and showed you where Texas agreed?
I believe you.
Oh,
no,
okay.
I believe you. Yeah, I mean, I believe you. I just think that there are bigger things in play than just that one item.
Okay, well, would you agree that at least there isn't an issue with respect to allocation of production? Because the states have agreed it could be by surface acreage?
I would agree that seems like a plausible solution, but what I can tell you is that has not been put forth in front of our director for approval.
So I'm turning now to the application. And this is tab 1 of part 1 of 2, PDF page 1 of 2, PDF page 4. And that's the application. Turning to PDF page 5, paragraph 5, the application states production will be allocated to New Mexico and Texas, prorated on the basis of surface acreage in the proration unit, or in any other manner mutually acceptable to the division and to the Railroad Commission. So with all due respect, I think we've asked that the director approve allocation based on surface acreage. Would you agree?
So I do, but the last part that says, or any other manner approvable, I can't, that part, I think is part of that broader conversation of all of these other agreements with the MOU with Texas. I mean, I don't take any one of these concerns or differing regulatory frameworks of either state in isolation.
And so now I just want to turn to, this is in part 2 of 2, PDF page 144, tab 21, applicant's second status report and request for approval. So here we've got attached the final order as Exhibit 3. It's attached as Exhibit 3 to tab 21. And I apologize, I don't have the PDF page number here, but I'm going to guess it is somewhere around PDF page 153, 154, somewhere around there.
So I do not have that pulled up in front of me. I'm hoping that you'll reference the statement that your question is going to refer to.
Oh, okay.
Or just read it or.
Right, so on page 3 of 7, with respect to the final order issued by Texas, paragraph 20 says Titus proposes to allocate production based on either surface acreage or wellbore length. And then paragraph 21 says the proposed alternatives are reasonable. And then paragraph 22 says production will be allocated on a basis mutually acceptable to public agencies having jurisdiction in Texas and New Mexico. So the way I read this order is that Texas has said either way works for it. So my understanding is we've asked the director how she would like to allocate production. And we've given her 2 alternatives, and Texas has said that either of those alternatives is fine. So all the director has to do is choose one or the other. And so I guess that's, and I'll leave it at there. I don't want to I'm beating a dead horse at this point, but my only point, there doesn't seem to be an issue regarding allocation of production here. And I guess I kind of want you to agree with me, but if you can't, I understand that.
Do you have a question, Ms. Shaheen?
Yes, and my question is, would Ms. Pollock agree that the issue of commingling is not an issue with respect to this application?
I will not agree to that at this moment in context of the broader issues at play. I think that is part of a host of issues that the OCD remains concerned about. I absolutely understand that some agreement has been reached and some solution has been proposed on commingling. Let's pretend that I do agree to that. There are still a lot of other issues at play here that need to be settled. And so what the OCD has asked for in Mr. Tremaine's questioning of me wouldn't even get to the part of commingling yet. It would say, hey, an MOU needs to be put in place before you're able to frack at the very least. And so we wouldn't even get to that stage yet.
Okay, so my question, you reference a number of other issues. So let's be specific. Provide me an example of one issue that exists with respect to this application, drilling from New Mexico into Texas.
Have we talked about casing design? Have we talked about reporting requirements if any type of issue happens? Are they different between the 2 states? What is, et cetera, et cetera? I mean, anything from well design all the way through remediation and plugging. Anything in the well life, we differ between the 2 states on a host of fronts, and we have communicated, I believe, effectively that we wanted that MOU in place before development of this project.
And so Titus, and I probably, here again, I'm beating a dead horse, but Titus has agreed that it will be in compliance with both New Mexico and Texas requirements. So whichever requirement is more stringent, that is what Titus is going to do. And so with that in mind, I guess I have the same question that I asked before is, what issue do you foresee with respect to this well drilling from New Mexico into Texas? What difference between regulations do you see could become a problem?
Objection asked and answered.
And you have it. Ms. Shaheen, if you want to continue with your line of questioning, but she has answered that multiple times. You've asked it using multiple different iterations of wording, but same question over and over. In addition, I'm just going to do a time check here. It is 11:58, and we're either going to need to break with your questions, or do you have an estimate on how much longer your questioning will take, and that will dictate when we will take a break?
I'm going to guess that, first of all, I appreciate you telling me to stop with that line of questioning. I would be guessing 10 to 15 minutes. But what I would suggest is that we take a break for lunch and let me spend some time refining these questions and making sure that I'm being as expedient as possible, if that is acceptable.
Yeah, so why don't we take a break? It's 11:59 at this point. So why don't we come back at 1 o'clock? We will continue with your questions and then go through the rest of the parties. So Ms. Pollock, you will be up again at 1 o'clock. All right, thanks everybody.
Thank you.
Because my computer clock is now 7 minutes slow, 1:02 on the 28th of September, and we will resume the hearing in case number 21872. I think we left off Mr. Tremaine with the finishing of questions from Ms. Shaheen to Ms. Pollock. Sorry.
Thank you. I'd just like to start by thanking Ms. Pollock for being so gracious with my what seems to be a little bit redundant questioning. I appreciate that, and I think I've streamlined my remaining questions. And I'd also like to take this opportunity to thank the commissioners for their patience and for setting this for a hearing today. So with that, Ms. Pollock, you testified in response to some questions from Mr. Tremaine about the purpose of the setbacks. And if I understand your testimony correctly, the purpose of the setback is to provide maximum recovery of hydrocarbons within the spacing unit and prevent the drainage of minerals in the offset tracts. So just want to make sure I understand that you're protecting minerals here. The offset tract are Texas minerals. Is that correct?
That's correct.
And so is it the division's position that the division is charged with protecting Texas minerals?
No, the division is charged with making sure that we don't cause drainage outside of our official lease. In this case, that happens to be Texas on the other side. Even in our state, though, we want to make sure that we're not draining from a lease outside of the lease in question.
Right, but with respect to this particular application, the minerals that you're protecting are located in Texas, isn't that right?
Correct.
Do you personally have any experience with interstate wells?
I have to think through my career here. Um, not that I can specify. I think there may have been some up in the North Dakota area, but not that I can specify or recall any specifics on that. So.
And that would be between North Dakota and another state?
Correct.
And do you recall what the other state is?
Gosh, I think it was, no. And you know what? Let's just for the purpose of this testimony say no, because I wouldn't be able to recall what my specific involvement is other than cursory.
Okay, but you do have a recollection of some interstate wells that
I
you
do. I mean, there's been conversations I've been part of in the past. In some cases, it was about the sale of mineral interests versus the development. Yeah.
And so now coming back to New Mexico, and I think there was some previous testimony about a well that was drilled in Texas into New Mexico, correct?
That's correct.
And I think it's the Medwick 32-1H, something like that. Does that sound familiar?
I will trust you. I have no idea the name of that well, but I'm aware of the situation with that well.
And are you aware that at one time the division had communicated with the Railroad Commission about interstate wells where production only occurred on one side?
I have no doubt those conversations happened. I was not part of those conversations then.
And you can't describe those conversations between?
No, because I believe if I remember correctly, the well in question, the approval for that happened a couple years ago, and that would have been even before my time at the division.
Do you know whether there is a MOU that addresses that well?
No, there's not an MOU that addresses that well.
And why not?
Because the well is, while the wellhead is residing in Texas and drilling into New Mexico, all of the production is from New Mexico, which makes it very different than this case in which the lateral is going to sit across two states, as well as the resources coming from both states. In that example, you're giving the resources are purely coming from New Mexico.
And so is it your testimony today that there aren't any issues related to having a surface location in Texas if there isn't production on both sides of the state?
I would say that there can be issues with that. I would say that in the past we have chosen not to venture down an agreement path. I would say largely because in that instance we were in a different regulatory administration and regime. I would also say that it was a very different case. It was a very different case without the resources coming from both states.
And are you aware of any issues with that well?
Not to my knowledge.
And is it subject to New Mexico regulations with respect to venting and flaring?
I am not sure how that well is specifically being regulated.
So you don't know whether that operator is complying with New Mexico regulations with respect to that well?
It is my recollection that they are, but I can't for certain say which portions of that they are.
And do you know whether they're also complying with Texas regulations with respect to that well?
No, I don't know.
And to your knowledge, there hasn't been any disagreement between Texas or New Mexico regarding regulation of that well. Is that right?
That's true.
Do you know about any interstate wells between New Mexico and Colorado?
I do.
Tell us about that.
I'm cursory aware of some wells that were approved and developed again before my time, that the surface location exists in New Mexico and the resources are being produced solely out of Colorado.
And do you know whether there's an MOU that addresses that well or wells?
No, there's not. I think there's two reasons for this. One is, again, it is not a commingled resource across both states. It's purely being produced out of Colorado. The wellhead is being regulated by New Mexico. And I believe, and I hope I don't misspeak here, that some of those wells also have some tribal authority associated.
And are you aware of any issues that relate to any well that is drilled from a surface location in New Mexico into Colorado?
No.
Do you know whether that well is also subject to regulation by Colorado?
I'm not aware of that.
Do you know whether there's been any dispute between New Mexico and Colorado about regulation of that well or those wells?
Not to my knowledge.
Do you know whether the division has made any effort to contact the folks in West Virginia or Pennsylvania that were identified by Mr. Jones in his supplemental affidavit?
Yes, I believe in one of my status updates, I was told that we had a staff engineer reaching out to those states to try to gain more information. I'm not aware of what information was obtained, if any.
And do you know which engineer that would have been?
I believe that was, I'm not certain. I don't want to misspeak.
Okay. That concludes my questions for you. I would like the opportunity to make a very short closing statement, Madam Chair, if and when the commission is so inclined. Thank you.
Thank you, Ms. Shaheen.
All right. Mr. Tremaine?
I do have
Were
some
you
redirect.
raising your hand? I think we're gonna leave redirect to the end after everybody's asked questions, but you'll get an opportunity to. Mr. Kolinsich, do you have any questions for the witness?
We do not. Thank you.
Okay. Mr. Feldwart?
I believe that
Madam
he
Chair.
indicated he was not coming.
Yes, Mr. Feldwart did email during the lunch hour that he would not be attending the rest of the hearing.
Okay. Well, good for him. Mr. Rodriguez?
No question, Madam Chair. Thank you.
All right. Commissioners? They're Mr. Baca or Mr. Warnell?
Commissioner Warnell here.
Go ahead.
Sorry, Mr. Baca. I have one question of Ms. Pollock. Good afternoon, Ms. Pollock.
Hi, Commissioner Warnell.
My one question is, do you know, has there ever been a permit denied because of an MOU?
I have not heard of that case, but I could not speak for certainty.
Sorry about that. Sorry about that. That's all I've got. Thank you.
Hi, Mr. Baca.
Thank you, Madam Chair. Just to make sure I heard it right after the lunch break, going back to some of the testimony you had before, was there a statement that OCD was okay with the drilling into Texas, but not producing from Texas at this point until an MOU was obtained?
Yeah, our initial preference is that no further development activity happen prior to MOU. However, if the commission were to grant a conditional approval, we could agree to drilling the well and then awaiting an MOU for any perforation.
Okay, great. Thank you for that. That's all I have.
I just have a couple questions. So at this point, there isn't active AP or an approved APD for this well. Is that correct?
Can you restate that? You cut out, Madam Chair.
Sorry. Is there an approved APD for this well?
Not to my knowledge. Well, I can't say for certain.
Sorry, let me look.
I may be able to answer that question if it would be helpful.
It would be, can she, Mr. Moander? Procedurally?
Sure, if could she or Ms. Sheen, can you direct us to a document that might help with this?
I'm pretty sure it's somewhere in the record for the division. Let me see if I can. I'm gonna start with tab 9 and see if it's in Mr. Jones's affidavit.
I'm trying to confirm is basically like, is there approved APD, but not an approved commingling application? Is that where we are here?
My understanding, and here again, I'm looking to see where it is in the record. BLM has, there's an approved APD by BLM, but it's only for that portion of the spacing unit within New Mexico. And Titus has been informed that it can, that same approved APD will apply to the well drilled into Texas once a sundry has been submitted and approved. If that makes sense. But the division has not approved an APD.
So may I, if I can? So I appreciate that help, Machine. The clarification is what I needed. So is there an approved APD? Yes, on the BLM side, no for the division side. And then there's lots of conversation around conditional approvals of APDs, which is where we are now.
But we're also talking about the commingling application.
That's correct.
Okay. So one of the things you mentioned was concerns with well design. Does the division have concerns with what BLM approved in the application for well design?
No, I think that the division's larger concerns are around making sure that well design go ahead.
No, go ahead.
Whether well design requirements among the two states, because the lateral sits in both states, are acceptable.
Okay. So potentially an MOU could, in relation to this one application for commingling, just this application for commingling, an MOU could serve a purpose as to specifying the well design and getting agreement between the states, yes or no?
Yes.
And so that could be one reason that an MOU might be necessary.
Definitely.
And for this one application, again, in relation to just the commingling, an MOU could serve the purpose of defining the production allocation, yes or no?
Yes.
Okay. Even, do you think that, okay, so go, maybe taking that back, stepping back to what Ms. Shaheen said in her line of questions, that Texas doesn't care how the production is allocated, they'll go both ways. Is it the division's position that an MOU would be necessary to solidify what type of allocation is used?
Yes, it is.
Okay. I believe there was something in, I can't put my hands on too many documents open. I believe in the division's testimony, I'm sorry, not testimony, pre-hearing statements, that they indicate that the commission does not have the authority to dictate what's in the MOU. Is that correct?
That is correct.
So it would it be the division through the Energy Minerals Department executing the MOU?
Correct.
Okay. All right, I think that's all I've got.
Madam Chair, I have a couple questions, if I may.
Yeah, I just looked down at my notes and I had one more quick one. So
okay.
just to confirm, and I think this is what you said to Mr. Baca, the division would be I guess proposes approving the application with the condition that they can not, basically they can go all the way up to the, sorry, I'm not speaking well. They can drill into Texas, they just can't complete the well, correct? And begin producing from it.
That is correct.
Okay. And that it be that production and the completion and production be contingent upon executing an MOU, whether it's for this application or multiple applications.
That is correct.
Okay. But specifically, the MOU would just have to clarify for this well, right?
Yes.
Okay. Right. Mr. Moiner, go ahead.
Good afternoon, Ms. Pollack. Thanks for coming back after lunch. So one of the questions, I want to flesh out something that Ms. Shaheen asked that I don't fully understand the answer on. Ms. Shaheen asked about a question approximately along the following lines. Now, based on the Texas Railroad Commission findings, you were asked to agree that commingling is not an issue in this matter. Your response was that you would not agree based on bigger issues. So what I'd like, and I think you've clarified what the other bigger issues are. I believe Madam Chair just asked some questions that kind of outline those. But for the sake of argument here, let's remove whatever you meant by bigger issues. If we take those as existing, but we remove them from the query, is it still your position that the Texas Railroad Commission findings combined with what's going on today, they do not resolve the commingling issue?
So if we're referring to commingling as just production allocation, is that?
That's
okay.
Correct.
Okay. I think it is my position that I don't yet understand how all of those intricacies work. Namely, I might mention, gas capture. And those conversations are, to my knowledge, still being had between council and staff. And so while I fully accept that Texas has made a statement in their hearing around this, what I'm not at full understanding is that the division has said that that is it, that we agree to that.
Okay, that's what I wanted to just get clarity on that because it was starting to get muddy. Thank you. Oh, one other, and this, this question may draw an objection from your counsel, but also ask him, but do you anticipate the MOU would potentially involve the OCC and not just the division? And again, if you don't feel comfortable answering that, I do understand.
I can answer to the best of my knowledge, then I will invite the legal team to go at it. To the best of my knowledge, it's not the the OCC's charge to define the MOU. It would be the division's charge. It's my understanding that the OCCs can say you need one, but then the division would have to go work that out with parties involved.
Okay, thank you.
Sorry, I have one follow-up question. So just again, stepping back to the application that is in front of the commission, just that application, is it the division's position that in order to manage the production allocation issues, there needs to be an MOA?
Yes.
Okay, thank you.
Madam Chair, something that just occurred to me is I've heard MOU and MOA. Is there any objection to using those terms, at least for purposes of this hearing, as interchangeable, so that way the record's clear?
No objection from me. I think I was probably using them interchangeably.
That's okay. I just want to make sure there's no disagreement that those are effectively interchangeable for purposes of this hearing.
That's a good clarification. Thank you. Mr. Tremaine, do you have redirect?
I do have a couple questions. So Ms. Polak, I want to follow up with you regarding the other interstate wells, the one well in Texas and which serves as whole location, and the one that crosses the border to Colorado. So has the New Mexico regulatory environment changed since those wells are drilled?
Yes.
And what new rules have been put in place since those wells were drilled?
Well, I probably, I'll name a few and then, but not limited to, because some of that was before my time, but
what are the big ones?
Just this past year, the waste rule regarding reduction of methane, venting and flaring, and the spill rule are two of the bigger ones here recently.
Thank you. I have a couple questions. I think Mr. Molander's question really addressed this, but I want to make sure that it's clear in the record the issues of commingling and production allocation. So is it true that from OCD's perspective, the commingling of resources across the state line is the primary difference between this proposed well and the other proposed wells for which there are not MOUs in place?
Yes.
Okay. Is production allocation OCD's only concern?
No.
Do you agree that Titus has requested OCD and now OCC approval of surface acreage allocation as a resolution to production allocation issues?
Yes.
And is it also true that OCD has not yet agreed to surface acreage allocation as that resolution?
That is true.
Okay. You were asked a series of questions about OCD's concerns related to this specific well, so I want to touch on some further points that address the chairwoman's questions. In regards to this particular well, could an MOU define the applicability of natural gas capture requirements?
An MOU could, yes.
Could it define who gets the production reports and what information is included in those production reports?
Yes.
Could it define whether or not Texas has access to inspect the well?
Yes.
Could it define who would pay to plug and abandon and remediate the well if it was orphaned?
Yes.
Okay. I want to ask you a couple questions about Titus's argument. Have you generally reviewed Titus's argument in support of their application filed as part of the pre-hearing statement for this hearing?
Yes.
Are you aware of Titus's argument that an MOU is not necessary?
Yes, I am aware of that as of the pre-hearing statement, but prior to that, I'm not aware of any objection that Titus had to an MOU being put in place.
Are you aware of Titus's argument that the MOU is not necessary because their proposed well will be drilled from New Mexico into Texas?
Yes.
Are you aware of Titus's argument that an MOU, if it's necessary, should only address wells that are drilled from New Mexico into Texas?
Yes.
What is OCD's perspective regarding a one-sided approval of a well or a one-sided MOU?
OCD would not be in support.
In your opinion, as the Deputy Director of OCD, is it good policy to approve wells that are drilled from New Mexico to Texas, but potentially deny or condition wells that are drilled from Texas into New Mexico?
No, it wouldn't be good policy. We want to support a fair agreement to both approve and deny wells on either side, and certainly wouldn't want to create any type of precedent where operators could choose which regulatory environment they want to be a part of, because as we've already talked, the regulatory environments change over time greatly.
No further questions. Thank you.
Thank you. Can we take a quick 10-minute break and come back actually probably at 1:45?
Am I dismissed?
You are dismissed.
Okay, thank you, Madam Chair and Commissioners. I appreciate it. Thank you, everyone. Nice to meet you.
Thank you.
All right, with that, let's see. State Land Office, I don't believe, are you planning to present any witnesses today?
No, Madam Commissioner, thank you.
Sorry, I'm having a hard time hearing you. I don't know if I'm the only one.
No, Madam Commissioner, thank you.
Okay. If the commissioners have any questions for the State Land Office, could we address them to you?
Yes, Madam Commissioner.
Okay. Do any of the commissioners have questions for the State Land Office?
I do not.
Mr. Warnell?
I have none, Madam Commissioner.
Okay. Maybe I'm the only one. I just have maybe a quick clarifying question. So is it the State Land Office's position that there should be an MOA in place before this well produces?
What the New Mexico State Land Office did is we removed our opposition and no longer take any position with respect to the application. We've been quite clear that there is a need downstream for an MOU or an MOA to delineate the responsibilities between the respective parties. But because we received these, I guess I would say concessions, negotiated deal points to resolve our conflict with Titus, we removed our opposition to this application, whatever that means.
So you don't oppose the application, but you do still think there should be an MOA or MOU or whatever to clarify some of those points that you listed?
Indeed, Madam Commissioner, and that's the way that agreement was written, albeit somewhat hurriedly, was to at some point, if there is an MOU, those are talking points, deal terms, which actually I pulled from some of the documents or some of the testimony that was submitted before the Texas Railroad Commission.
In your agreement with Titus, is that agreement contingent upon an MOU, or it just makes the recommendations?
Our position is that we were in support of those specific conditions for approval, no matter what was ordered by the OCC to remove our opposition to the application.
Okay. All right, that's helpful. Thank you.
No, thank you.
I believe Mr. Wart is not with us any longer. Mr. Rodriguez, are you planning to present any witnesses today?
No, Madam Chair.
Ms. Shaheen, do you have any rebuttal witnesses you intend to present?
I do not. Thank you.
Okay. Mr. Moander, I can't recall. Do we close the record before we go to closing arguments, or is it open through closing arguments?
The record should remain open through closing arguments, at which time it'll close, or the record would close. But as a reminder, closing arguments are not evidence. They are just that, argument.
Thank you. All right, Ms. Shaheen, would you like to make any closing statements?
Yes, I'll try to be as brief as possible. As we've stated, Titus does not believe that an MOU is required here to approve this application. To the extent that the commission feels that an MOU is necessary, Titus agrees that it should only pertain to this particular application. And in any event, it should only pertain to wells that are drilled from New Mexico into Texas. And I would note that that is part of our agreement with the State Land Office. The State Land Office supports that position. To attempt to solve issues that may arise for wells drilled from Texas into New Mexico, is not what this application is about, and it's not what any of Titus's future development plans is about. And it's therefore unnecessary at this time. If at any time in the future, another operator or even Titus decides they want to drill from Texas into New Mexico, then at that time, they can come to the division and seek whatever approvals they need for those types of wells. Titus tried diligently to reach out before any filings were done with all of the agencies, and it was difficult to get feedback for weeks and even months. As a small company, they were required to proceed with their drilling program, even though this has taken longer than anticipated. The state of Texas, which is actually the state who has the most risk here, has already approved drilling of this particular well. And that's all Titus is asking for here. If the division, if the commission were so inclined to condition an approval on an MOU, condition completion of the well and production of the well based on an executed MOU, Titus would suggest that it allow drilling and completion, but not production, because there are safety concerns that could arise with having to drill and then come back later and complete. The question I think is one question that's raised, legal question, is whether the commission has authority to deny the application based on the division's speculative concerns, particularly here when the proposed well satisfies the core mission of the commission by preventing waste, protecting correlative rights, and minimizing environmental impacts. And I would cite to Continental Oil Company versus Oil Conservation Commission 1962-NMSC-062. The prevention of waste is of paramount interest. And in this event, with respect to this application, Titus would be required to comply with all New Mexico regulations. And I think that completes my closing statement for now.
May the NMSLO clarify one minor matter, please? Not argument, just clarification.
I think you can make that clarification during your closing statement.
Thank you very much, Madam Commissioner.
Okay, Mr. Tremaine, do you have any closing statements?
I do, and I also will attempt to be very brief. We've had a lot of discussion about production allocation today, and that is, in fact, the only question posed to the Commission by Titus's application, but that production allocation concern is not the controlling concern for the OCD, and is frankly probably the easiest to address. But the OCD believes that the production allocation would most appropriately be addressed in an MOU. I want to address another point about the authority to deny the application, and I want to be clear that an MOU is not specifically a requirement in Titus's application. If the OCC determined it was appropriate to deny their application, it would not be on the basis that there was a lack of an MOU. It would be on the OCD's presentation that the OCD cannot protect the interests of the state of New Mexico absent reasonable certainty regarding the regulatory environment. Texas is not a party to this proceeding. Titus's assurances that it will comply with New Mexico regulations do not constrain Texas's conduct, and Texas, I think, can reasonably be foreseen to potentially take issue with application of New Mexico rule to Texas minerals. And the inverse is true in the event that a well is drilled in Texas and extends into New Mexico. That's not speculative. That's projectable. The MOU or the JPA is simply the mechanism to provide a reasonable amount of certainty as to how the parties are going to cooperate and how to jointly manage wells that are commingling mineral resources from two separate states. That's the goal of getting an MOA or MOU or JPA. It really doesn't matter what we call it. I want to address the authority question that came up and clarify the OCD's legal position. The OCD and this commission have concurrent authority. So the OCC could require various actions by the OCD, and the OCD will comply with whatever those demands are from the OCC. For instance, the commission could tell OCD to negotiate or continue negotiating an MOA. You could tell the division to be ready to execute that agreement by a certain date. You could indicate what the commission wants included in an MOA. But what you can't control is the Railroad Commission's participation in that, or the ability of the parties to reach an agreement and execute agreement by a date certain because of those third parties outside of the control. So I want to be clear that the division is not taking the position that OCC generally doesn't have jurisdiction to look at these issues or to weigh in on an interstate agreement. In fact, under the JPA, I think, which was presented by the division as it is a clear authority for the agency to directly negotiate with an agency outside of the state of New Mexico, that the OCC could keep the negotiations with the Railroad Commission. I don't see a distinction between the division and the commission in terms of the JPA's applicability, but the OCD would recommend to leave that negotiation with the OCD. That's simply our recommendation. So I hope that provides some clarity on the legal position of the division. And yeah. The bottom line is that OCD does believe that an MOU is necessary prior to further activity, but especially completion and production on the well and the instant application. While we understand Titus's resistance to the OCD looking at issues larger than Titus's application, the OCD feels it is untenable to treat wells moving from New Mexico into Texas differently than wells coming from, originating Texas and coming into New Mexico. The OCD doesn't believe that sets New Mexico and Texas up for an agreement that's mutually beneficial, and it will the precedent set by accepting that the rule at the wellhead applies for all minerals extracted from that wellhead will create an incentive, which could shift over time between the states, for operators to seek out the most friendly regulatory environment. So approving the application will be argued that it stands for the propositions that interstate development is acceptable and that the rule at the wellhead controls. And what OCD wants to avoid is getting into any protracted negotiations after the fact with the state of Texas and avoid any potential legal disputes down the road. It's intended as a preventative measure. Thank you.
Thank you, Mr. Tremaine. Will the State Land Office have a closing argument?
Yes, Madam Commissioner. Thanks very much for the opportunity to be heard. I just wanted to clarify one important point on the record. I thought I communicated on an open, but it's possible it got lost when I was reciting the potential deal terms. This is a negotiated resolution in a particular set of circumstances, and we thought it was agreed that there would be no argument. This single one-off deal would be precedent for drilling in one direction or the other. This was a situation where, because we had a situation of uncertainty, both before the Texas RRC, with any decision here, and with the potential or possibility of some waste in the future, that we could get some sort of a resolution or some sort of a stipulation with counsel for Titus on those, I believe it was 11 deal points, which I articulated at the very beginning. It wasn't meant to be, again, it was not meant to be precedent. This is a situation where we have a one-off, we have an applicant who maybe maybe, I don't know, maybe isn't 100% entitled this, but we removed our opposition on the basis that this was a one-off, not some sort of precedent for future deals. That's the only thing that I'd like to make 100% clear.
Thank you.
Thank you.
Mr. Feldord is not here, so Mr. Rodriguez, do you have a closing statement?
I do not. I just want to say thank you all for your time.
Thank you. Ms. Shaheen, do you have any rebuttal closing statements?
I do not. Just to echo Mr. Rodriguez, thank you all very much for your time.
Thank you. So the record of this application hearing is now closed. Mr. Moander, in this situation, can the commission go into a closed session to discuss this?
Let me, I was afraid you were going to ask that. Let me take just one look to be thorough at OMA. My suspicion is probably not, but let me take a look and give me just one moment, please.
Okay. Historically, for technical matters, we have been able to, but confirming would be great.
Yes, Madam Chair, and I apologize. This tells you what type of hearing we had when my poor Adobe is slowing down from the volume of PDFs I have open. But I do believe that the commission under New Mexico Statute 10-15-1 sub H sub 3 applies here. Deliberations by a public body in connection with administrative adjudicatory proceedings, because there are legal rights, duties, and so on to be determined after a trial type hearing. And at this point, the commission has complied with the requirement of this provision that the actual administrative adjudicatory proceeding during which evidence is offered, rebutted, and then ultimately final action taken must be done in open meeting. And I anticipate the commission will render its decision after a closed session.
Okay, so that's a long-winded yes.
Yes, it is. I've got to make that record, Madam Chair.
Okay. I'm trying to think what the mechanism would be to do that. Should I, if
So,
we were
Madam-
to make a motion to do that?
Yes, so because we didn't necessarily address this because it wasn't the pressing issues of this adjudication. Generally, there's a motion to close. Again, it's 10-15-1 H3 that the meeting would be closed pursuant to that section of OMA, and that the only matters to be discussed during the closed session are those that were presented by the parties for purposes of this hearing.
If there is that, yes, I'll ask that question in a second, but if there theoretically is a motion and that we're approved to close per the section 10-15-1 H3, would I like set up a separate maybe meeting invite for us?
That's usually what's done, but we could also ask the parties to check. I don't know, we could have the parties check in and we could excuse everybody. That may be simpler unless it's going to be real easy to generate a link on your end.
Okay, well, let's first see if that's what the commission would like to do, and then we can cross that bridge. Is there a motion to for the meeting to be closed pursuant to the administrative adjudicatory deliberations exception to the Open Meetings Act, Section 10-15-1, H sub 3, to deliberate only matters for case number 21872.
I make that motion.
Is there a second?
Madam Chair, I second that motion.
Mr. Melander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Baca
Yes.
and Commissioner Warnell.
Yes.
Madam Chair,
Yes,
the motion unanimously carries.
thank you. Okay, so the commission will now close the session and the record. I think, Mr. Baca, are you guys able to use Teams, and Mr. Warnell, or can you guys all use and get on Teams?
Madam Chair, I've had one meeting through Teams and it seemed to work okay.
Okay. All right, for ease, I'm going to send out a link to Mr. Warnell, Mr. Baca, and then Mr. Moander, and everybody else can hang tight here. I would just remind the commissioners, if you want to, you can leave the meeting on here and then rejoin, or make sure that you're muted and all of that jazz for this meeting, or turned off your video for this meeting. If you have two meetings running, I will have to continue to have this meeting running so I don't kick everybody off. Okay. All right. Well, with that, the public can remain on this meeting during the closed session and wait for the commission to reconvene. Thanks, everybody. We'll be back. Resume button. I'm just going to repeat that really quick for that video recording. I know it's on the transcript, but it is a little after 3 on the 28th, and the commission meeting and the record are now open again. The discussion during closed session was limited to the deliberations in case number 21872. All right. And with that, commissioners, I think, is there a motion in this matter? Actually, I may waiver a motion here. So in the matter of case number 21872, I make a motion to approve the application with some contingencies to that, that the well cannot produce without having a broader agreement with between New Mexico and Texas in place. In addition, any substantially similar proposals from the applicant or other applicants need to come directly to the commission. And third, that the division, starting during the January 13th, 2022 regularly scheduled commission meeting, needs to provide both a written update as well as appear at the January 13th hearing to provide an update on the status of the MOU. 2 business days prior to the January 13th regularly scheduled OCC hearing, The division should file a pleading which indicates the status update in writing. After that, every 90 days, the division needs to continue to provide these updates to the commission, including the written pleading 2 days prior to the regularly scheduled meeting, and then appearing at the regularly scheduled OCC hearing meeting, basically every 90 days after, until an agreement between New Mexico and Texas is executed. Is there a second to that motion?
Madam Chair, I second that motion.
Thank you. I would open it up for discussion before we take a vote on this, and I think would like to start off as to why I made the motion, and why it entailed those pieces. You know, the commission is charged with preventing waste and protecting correlative rights. And in order to do that, there needs to be a level of certainty. And I think all of the parties had recognized that this is a, in general, sort of unprecedented situation. It's not something that is done daily and or regularly. And that, you know, drilling across state lines and having interstate issues has inherent uncertainties. And in order for waste to be prevented and to ensure correlative rights for all of the interested parties, we need to have a level of certainty, and that will come in the form of an agreement between New Mexico and Texas. Are there any other thoughts or comments from the other commissioners? Okay. With that, Mr. Molander, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Baca,
Yes.
Commissioner Warnell,
Yes.
and Madam Chair.
Approved.
The motion carries unanimously.
Thank you. With that, Ms. Shaheen, would you please draft and circulate a proposed order prior to the 8th, or by the end of the day on October 8th, so that the commission can take this matter, or the final order up during our regularly scheduled meeting on October 14th.
Yes, yes. I don't know if it's appropriate for me to ask clarifying question.
Mr. Molander, I'm fine with that.
Yeah, I don't have an issue with that. And, you know, it's something just occurred to me, Madam Chair. Let me double check. There may be one provision we need to account for here in some of the regulations, but I'm happy. I'm listening to Ms. Shaheen.
Okay, go ahead, Ms. Shaheen.
I guess the question that I have is what is meant by a broader agreement? That seems to be a little broad in itself. So I guess that's my question is, what does the commission envision being in the broader agreement between New Mexico and Texas?
I think it needs to provide a level of certainty again in order to manage the issues of preventing waste and protecting correlative rights. There was, I think, testimony by the division as to the limitations of the commission being able to dictate the direct terms in those agreements. And so it would need to relate to basically address how this well will be managed and things such as production allocation, et cetera, and provide certainty of that. Mr. Moiner, is there anything additional?
Inviting the lawyer to comment. I think, Ms. Shaheen, what the commission is looking for here, and I'm not speaking for it, so I may be corrected, is there have been several issues, and this agreement is not limited to those issues, but ought to at least include them, which is going to be issues of, allocation it's not a big one, but it's an important, not the biggest one, but that's important. The other issue is going to be, give me just a second. Let's see. So we got the wells, even I don't have a mastery of the vocabulary quite yet. Madam Chair, you might help me. Basically, not the schematics, but the well structure. Some of those the other
casing requirements.
Yeah, casing requirements. There we go. I knew you'd have an answer for that. I think those are at least two items, but we'd be looking for as comprehensive as possible agreement between New Mexico and Texas that incorporates those two items in particular, but not limited to them, so that wells that are going to be drilled interstate have some regulatory framework they can work under that's clear and the parties can rely upon.
And would that be only for wells drilled from New Mexico into Texas?
It'd be great if it was more comprehensive than that, but that would be a scope issue that I would anticipate being dealt with in particular. But I would imagine if this goes as, I'm not going to say has been promised, but it's sort of been argued, implied, both sides of that coin ought to be covered. I would expect that, but I don't know that that's the commission is not taking a position, and Madam Chair, correct me if I'm wrong, of specifying high level of detail on what this agreement needs to say, but it certainly needs to address the issues that are presented in this case. I think that's a simpler way of putting it, that have been presented by the parties.
No, that's correct. And I don't think the commission doesn't intend to dictate what that agreement entails in sort of specificity as to whether or not it just needs to address this well at a minimum. The issues for this case need to be addressed in that MOU, MOA agreement, whatever we want to term it, if it is written in a, so that's, yeah,
Thank you.
And one item, Madam Chair, that I'm going to suggest be addressed is the precedential value of this order.
this order, and you're going to have to remind me of the term here, only applies to the facts in this case. And sorry, what, Chris?
I'll make a proposal of language that you might adopt. Is
Go
that
ahead.
the order that the commission is issuing in this case is not intended as precedent for future cases and applies exclusively to the facts and the parties present before the commission in this matter.
Exactly. Any other questions, Ms. Shaheen?
Not at this time. Thank you.
All right, if you could circulate that by the end of the day on the 8th, and we can put it on the agenda for the, should write this down, let's see, October 14th hearing, regularly scheduled OCC meeting. Is that turnaround possible?
Yes.
Go ahead, Mr. Moiner.
Madam Chair, one other item. I'm going to ask our court reporter about the anticipated turnaround for this transcript in case, if the parties run into issue or having trouble with transcripts, obviously let me know, but I always like to ask the court reporter what her anticipated turnaround time might be.
Well, I think actually you guys kind of get priority. I'll have to set about 500 other pages aside, but I think Paul Bach is probably going to tell me to put yours first.
Okay.
So I'll just, this is probably about 150 pages, so probably middle of next week.
Ooh,
Too late?
okay. Would
That too late?
there, this is a constant balance between, court reporters and the attorneys who want transcripts yesterday of today's hearing. But I'd like to get this in at least Ms. Shaheen's hands to give her about a week. So close of business Friday, is that asking too much?
What are we on today? I've lost track. I was set for 3 different cases today and I don't even know where I am.
Today's Tuesday.
Tuesday. Yeah, I think I will set the OCD aside, and because it's just agenda items. There was no hearings on our last OCD, and Mr. Brankert said that would be okay. So I'll put you ahead of that and just work on it and get to you the fastest I can.
And Mary, if you're running into scheduling issues, please ping me as soon as you notice them, and I'll see what I can do to make this work.
Good. Well, I have one that I can ask for right now. When I interrupted Mr. Tremaine, I'm sorry, I was kind of rude. I told him he sounded like a robot. But what I mean is people, when they read, don't read with inflection. They just read words. And it's very, very hard for us. And so there's like 2 sentences in there. So if he has that on the computer, if he could forward that to me, I'll make sure that I make sense out of the jumbled words that I wrote. So that would be helpful. Otherwise, I'll just have to put in an audible. And as I know, as you said, opening and closing are not testimony. So if you guys don't care, I'll just put in an audible. I like to get it as accurate as possible. So that would be my one request. Otherwise, I'll start on it tonight and I'll get it to you just as soon as I can. And if it's not going to be Friday, I'll let you know Thursday.
Awesome.
Okay.
And the OCD ones can wait, if that helps.
Yes, that's what Mr. Brankert had told me. If I had a hearing that somebody needed, that I should do that, because I was trying to get them all ahead of everything. So yeah, that's great.
Yeah. This would take precedence over the OCD. So thank you.
Good. I'll keep in touch.
Thanks. All right. With that, our next meeting is the regularly scheduled OCC meeting on October 14th at 9 a.m. And with that, happy Tuesday, everybody. And I guess we will see most everybody again on October 14th. Thank you.
I have one other thing. Do you want me just to go ahead and do all the testimony, starting with the testimony?